In a world of rumors and reckless talk, one woman stands for truth. She doesn't speculate, she cross-examines. The courtroom is her kingdom, and justice wears heels.
Order in the court, let the facts be seen. Melissa Jade on the mic, call her crime scene queen. She don't do drama, she don't do lies. Every case get clean when she analyze. Cross that line, she'll object real quick. Logic so tight, it cut like a brick. Beautiful mind with a presence so loud. When she speaks, you can feel the whole room bow, room bow, room bow.
She studies every angle, every word, every lie. And when she speaks, it's not emotion, it's evidence.
No hearsay, just receipts on the table. She don't need fiction, truth's her label. Courtroom lights, blow her heels, click steady. Whole jury leaning like, man, we ready. They talk nonsense, she calls it out clear. Confident, strong, you can feel that in the air. She got the law locked and the facts in sway. Another case closed the Melissa J. way.
They came with theories, she came with proof. They had opinions, she had the truth. They had the theories, she came with proof. They had opinions, she had the
Beauty don't fade when the brain got bites. She shine like a verdict red late at night. Smart, bold, blow loud and still so graceful. Every sentence sharp and tasteful.
Some say justice is blind, but when Melissa Jade steps in, justice sees clearly.
Yeah, she walked through lies like a gavel crack. Truth in her voice, ain't no turning back. Debunking myths with a lawyer's flair. She don't chase clout, she builds it there. Applause in the chat, they know her name. Melissa Jade, she don't play games. Beautiful, brilliant, truth unafraid.
Bow to the queen of facts, Melissa Jade. The verdict is in, and the truth has a name. Melissa Jade. Melissa Jade.
Hello, everybody. Hi, it's Kirsten Lee. Holly says, I'm so ready for this train wreck dumpster fire of a mess. You and me both. Hi, Pink Pam. Hi, Tess. Oh, Captain, my Captain. Vicky, Midnight Lace, Julie A, Neat Noodle, Harper's Nana, Kimberly, Sunshine Mafia. Oh, hey, everyone. Yay, some Tuesday fuckery with this crazy bish. Oh, Laura Owens. Hi, G3NC. Hi, Harlot. I didn't get on Marie Joey yesterday for members only Monday, so we are doing Tuesday members only. So welcome. Thank you, anyone who may be watching and are not a member. You are still very appreciated. Make sure you are opted in so you have a chance at receiving a gifted membership. We have a very generous community, but hello. I'm so excited. Hi, Daniel. Yeah, it's MOT. Members Only Tuesday. Honestly, I like that better than MOM. I don't like the MOM acronym, but that's because it's already taken. It's MOM. But we are here to continue to go down this Laura Owens rabbit hole because I am just thoroughly invested and I want to know everything. And so I figured, even though I'm going so out of order, but who cares, right? At least it's consistently inconsistent. Hi, Kelly. Hi. Hi, Coffee and Skeletons. We are going to go back to the protection orders. And if you guys remember, that was before the injunction against harassment. I sent you an email today about Laura. It was I was on it. I didn't go on no podcast. What a twist. I wasn't expecting that. I sent you an email today about Laura. It was a podcast with a Laura timeline and you were on it. I guess you mean the timeline, not the podcast. That would make more sense. But I just hopped on this, but that's so awesome. I wore my special part. Oh my goodness. That is funny as hell. I need to get a screenshot of that judge because that was probably the funniest moment in that entire life. Why is that judge wearing a party hat? Me too, Kirsten. I'm like thoroughly invested and I'm just excited to get caught up to current date because there's a lot of stuff still happening. Yeah, the party hat judge. Yes. So, let me pull up our missing child and then we're going to get into it. And Shay may be joining us if she gets home. And so we have that to look forward to. So let's see, what state should we do? Let's do Wisconsin. Okay. So here is our missing child for the stream. I hope everyone's Halloween was fantabulous. Hi, Samantha. So here is Kaimani Moore. Kaimani has been missing since October 16th, 2025 from Milwaukee, Wisconsin. He is 12 years old. So if you or anyone you know has information on Kaimani's whereabouts, please contact the Milwaukee Police Department at 1414-933-4444. Okay. Yay, Tess. I couldn't fit my hat and my face in that. Honestly, Kelly, I like it more with just your eyes peeping through, honestly. It's perfect. It's perfect. Okay. Yes, he is very handsome. They put a bunch of podcasters together, and you were one of them. They use about 3 minutes of one of your lives. Oh, that's awesome. Carper's Nana. That's very cool. Okay. So what we're going to be starting with, and let me see if I could get this in order. I believe it is Laura's protection order that comes first. Okay. Laura's protection order that comes first. Yes. Okay. So the first thing I'm going to be starting with is on October 6, 2023, to the Scottsdale Police Department. Laura Owens calls the Scottsdale Police Department to report an OOP. No, I have to play the second. Sorry. I have to play this second because protection order was already in place. So she must have called the same day. Hold on. Wow. All right. So October. But if this is October 6th, hold on one second. I'm getting a little bit confused. Part 1. So here is her petition that she originally filed. I know that body cam. Oh my gosh, it was insane. Okay. So this is the protection order that she had filed. And it's dated October 6, 2023. So just over 2 years ago. Plaintiff Laura Owens, Clayton. Okay. And it says that the defendant-plaintiff relationship is one party is pregnant by the other and romantic or sexual relationship. If checked, which it is, defendant and I have a pending action involving maternity, paternity matters, okay, which they did with the court case FC 2023-052114. So, approximate date. This is tell the judge what happened or why you need this order. Print both the dates and a brief description of what happened. If there is a contested hearing, a judge can consider only what you write here. So she wrote approximate date, June 1st, 2023. Clayton has sent threatening messages since discovering I was pregnant, such as, I legitimately hate you right now. My hatred will only grow if you decide to put me through all of this. My animosity would last for a lifetime, and that's not something either of us want to subject ourselves to. One thing about me is when I wake up my mind for good, especially when it's rooted in anger, I don't sway. Ever my hate is towards you and you only. If you decide to not take plan B and in the wild event that you are pregnant, I would hate you even more. Okay? Oh, Samantha. But you know what, Samantha? Sitting at the door and handing out tricks or treats, and seeing all the kids' costumes is really enjoyable too. Okay, September 21st, 2023. Clayton was the Bachelor and has many diehard loyal fans. He and I are involved in a very public paternity case that is being covered by every major media outlet. Clayton posted to a story to his 270,000 followers to look me up, which they have. And I have been sent threatening and harassing messages by his followers. I explained this to him and asked him to take down the post, which he did not. By posting personal and sensitive information about me publicly, and again without my consent, he has made me feel humiliated and embarrassed. So September 21st, 2023, Scottsdale police officer Vince Johnson called Clayton to explain that what he was doing was harassment in and of itself, coupled with the fact that he was inciting his followers to harass me as well. Despite this call, Clayton still did not take down that post. October 5th, 2023, between September 22nd and October 5th, Clayton has posed as several users on Reddit, including Redacted and others. He has posted private and confidential information, including facts about my medical history that is known only to him because of our paternity case. This is why it is 100% traceable back to him. He has also been writing defamatory and very hurtful things about me, including comments about how I gained weight, I am pregnant, and how I am not attractive, how my photos are so poorly edited that it is laughable, how I am bad at my job, a self-help podcaster, and how my prior abusive relationship, which inspired a TEDx talk, never happened, despite mountains of evidence. He is doing everything in his power to ruin and hurt my reputation. As a result of what has posted, I have gotten harassing messages that have told me to harm myself as a result of becoming pregnant with his twins. I am getting other threatening messages as well. And all of this attention from the general public that he has incited is very much unwanted. As a result of this public shaming, he has caused me extreme psychological harm and disrupted my peace. I have asked Clayton to stop the harassment on Reddit and social media so many times, but he won't. I have reported his accounts and posts to Reddit, but he continues to write unacceptable, cruel things about me. He has multiple accounts now, and so even if one is blocked, he can create another one. As a result of him spreading false and damaging information under pseudonyms, I feel demeaned, humiliated, and like my deepest sense of privacy has been invaded. In addition, he has been in communication with my ex, who I have an order of protection against and who he knows is dangerous. I have asked him to stop talking to him because it will put me in danger, but he continues to communicate with him. October 6, 2023. When combined, all of this has led me to feel extreme anxiety and fear for my safety. I have not left my house since September 28th because of this. The following person should also be in this order. They should be protected because defendant is a danger to them. She left it blank. So it says defendant should be ordered to stay away from these locations at all times, even when I am not present. Residence, work, business, school, other. So let me see, what else did she click? Okay, and then she signed it. So she then would have an ex parte hearing. Okay. Hey, Wolfie. Yes, thank you. She would then be given the ex parte hearing, which is an emergency hearing where the petitioner gets to see the judge ex parte. The respondent hasn't even been notified yet, usually. And you get to essentially put on a case. Sometimes they want to see evidence, other times they don't. And they will usually grant an emergency ex parte order until both parties can come and present their arguments and sides. And that's when they'll move forward and determine if an actual protection order needs to be granted. Hi, Fishiggles. No, not really. I read the filing, but we're about to watch it, so you're good. Yeah, embarrassed and humiliated. So let me now jump to the OOP hearing, which again, this one would be Laura on her own with the judge, and then we will watch the one where Clayton joins next. Okay. So this is October 6th, 2023 for her OOP.
All right, good afternoon and welcome.
OOP. Why do I keep saying OOP? OOP hearing. Hey, Fragile Like a Bomb.
2023-052771 in the matter of Lauren Owens versus Clayton Echard. Ms. Owens, are you present on the line?
Yes, I am.
Ma'am, can I have you state your name for the record, please?
So she's on a phone line.
It's Laura Owens.
Thank you. And if you'll raise your right hand, let me know when it's up. I'm gonna have you
Hey, it's about time.
It's up.
You do solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, thank you, Ms. Owens. This is a hearing on your petition for order of protection. I'm going to ask you some questions about your petition. Before I do, are the statements alleged in this petition true and accurate to the best of your knowledge?
Yes.
And the nature of your relation.
So again, he's referring to that petition that I just read. Okay. Hey, Boots. He's referring to the petition that I just read. And again, this is ex parte. So this is an immediate hearing granting potentially an emergency protection order. But she's on the phone. So Clayton is not here, but she's on the phone and connected for this hearing.
Relationship with the defendant, Clayton Echard, is what?
So I'm pregnant by Clayton, and so we also had a romantic relationship.
Okay. Do you currently reside together?
No, we do not.
And are there currently any orders in place, protective orders in place involving either one of you?
I have a protective order against somebody, but there's nothing between us.
Okay. Now, earlier, well, let's see, it's been a couple weeks. A couple weeks ago, you had filed a petition against Mr. Echard involving some of the same circumstances that you've alleged in this petition, and the court at that time denied your petition. You know what allegations I'm referring to?
I do, yes, and there have been more, and there was even another one just since I filed it this morning.
All right, and I appreciate that. I saw that in your latest petition.
So she had initially filed a petition that got denied. And so since she's saying that there's more allegations, even as of current today, that I've included in my new petition.
The point I want to make is that because the court has already ruled on those other incidents, and specifically the one with the date associated with June 10th and the other with the date associated with September 21st, we're not going to talk about those issues today, but
So the reason that you can't do that is because it's called res judicata. What that means is when you've already brought claims before the court and it's already been ruled upon, and her previous claims for those specific dates and incidents have already been ruled upon, you can't bring those same claims back to the court and try to litigate them, which she is trying to do. So what he is saying is the claims that you've already brought forth on your previous petition has already been ruled upon. So I am not considering those today in this petition.
I do see that your latest petition does have events that are alleged to have occurred with the dates and I'm going to quote your language, between 9/22 and 10/5. And then you have another event that has a date associated with it of 10/6/2023, where you referred to since September 28th. So let's talk about those events in that time frame. What is it that Mr. Echard has done, and when did he do it?
Yeah, absolutely. So I just want to make sure. So can we talk? Or I'm sorry. He had just done something, and I'm really upset. So you wanted to talk about like when he posted to his followers about to look up my court cases against.
Ma'am, why are you asking the judge what he wants you to talk about? You're the one who listed those claims in your petition, and you chose to use a wide time frame of when these allegedly happened. So he is asking you to specifically talk about those two time frames that you are saying all the way up to today, the day that this court is being heard. Okay, it's the same day she's claiming. What happened between those dates, not the ones you listed on the previous petition? Like, answer. You're stuttering like crazy, Miss Owens.
Against, I mean, I have the protective order against.
Yeah, and I can facilitate our communication. Let me do this. Did any of the posts refer to you by name?
Hey, Gidget.
They did not, but he said because I asked to remain anonymous in this whole thing, but he said to look up the post by his name, and because of that, I've been named by like everybody online.
Okay, but did Mr. Echard post anything that referred to you by name?
No, he did not.
Did Mr. Echard post your case number in any of his posts?
He said to look up the case number.
That's a no.
All right. And
you know what?
And so he provided his name, right?
This, I love when litigants do this. You need to answer the question that you're asked. Humans have this desire to over explain. You need to just answer in a very black and white manner what the judge is asking you. So, right, Tess. So the answer is no. We don't need your explanation. We don't need, well, he guided them. The answer is no. And hi, Steph and Kat. Hi. Oh, Jean. MJ, you were on too early for me. I know. I come on straight from work now. Hope you had a happy Halloween. Also, is it too early to set up my Christmas tree? Let me know. I value your opinion. No. I was woken up by my spawn the morning after Halloween, November 1st, with a pot and a spoon with Mariah Carey. It's time. With the Christmas music blasting, and I nearly had a heart attack. We're all lucky I'm still here, or unlucky, one or the other. But point is, no, I love Christmas tree, and you could start putting that Christmas tree up as early as November 1st. Thank you so much for the support.
Yes, and he told people where to search on the Maricopa County website.
All right. And then what are the statements that were in the post that referred to you specifically?
So he said that I had done this. By this, he meant gotten pregnant by 2 other men before, which is true. And after he did that, he has posted many times just facts about the cases.
Facts about the cases?
I have a
I'm sorry, what did you say? So Judge, Your Honor, he stated I was pregnant by 2 other men 2 previous times, which is true. And then you want to know what, Your Honor, what he went on to do? Let me tell you what he went on to do. He went on to post facts about the cases. And I love that it's just a spill. You're actually letting it known that, yeah, no, he's not lying. He's posting actual legitimate facts about the cases. But do go on, Miss Owens.
Well, I have a civil case, and they're both against the same man. I have a civil case that I had given discovery materials to the man in the civil case, and Clayton was able to get a hold of those and leak those documents online, which those did have my name on them.
Okay.
And then Clayton has now posted that the results of the paternity test came back, which they did not, and he said he's the father. He's not the father, and again, they did not come back. He's posted this, and so then I'm just getting harassed like crazy. I just have to go and submit a retest. So he's really gotten people.
So let me ask you, Here's
Mhm.
the line of concern that I'm in what's directing my question. So, folks that communicate things publicly have a constitutional right to that includes a freedom of expression, and so long as their communication is not illegal speech. In other words, it's not well, illegal speech can include a number of things, but if the comments are true, or rather, if the comments are not untrue and they're not illegal speech, then they are generally protected free speech.
Yep.
So what is it about these posts that you claim are not protected free speech?
Well, so in the first one, when he said the initial cases, I guess I should have explained that a little more. He tried to make it seem like I had faked being pregnant. That was his insinuation, that I had, quote,
All right.
done this.
So how did he insinuate that? So and here's and this is let me distinguish
Yeah.
between what I'm asking and what you're saying. So
Yeah.
you can't draw the conclusion. All right. So tell me, what is he saying without
Right.
you drawing a conclusion? Because some people may not draw the same conclusion as you.
Yeah.
Use his words and tell me what it is that he said that you think is unprotected free speech.
It's
Or not,
relevant, well, for you for right
that's not
now.
free speech.
Just
Hi,
that
Russ.
he said he said that on his page, and then on Reddit he went online and he named me and he accused me of faking pregnancies.
No, ma'am, you can't claim that alt accounts or anonymous accounts are somebody. Even if you think that they are or believe that they are, if you can't prove that they are, you can't claim it was him doing that.
In the past, and he has cussed me out on there. He's harassed me. He himself had said that I really should kill myself on Reddit. And
Again, did he
and
refer to you by name when he made that statement?
on Reddit, yes, he did. He referred to me by Laura.
See, I wish the judge asked for some clarity here and looked at exhibits if she submitted any, because it was not Clayton that she was referring to with those Reddit accounts. She was accrediting those comments to Clayton, but it was different usernames that she's claiming are Clayton.
Owens, every time he posts on Reddit, he posts my full name.
Okay. And then when you use the word harass, what is it that you mean?
Well, I mean, like when he said that I should kill myself, and when he said that he said online that I have lied about being pregnant when I have not, and he has absolutely no proof that I did, and I've provided all this medical evidence to prove that I was pregnant. And despite that, he's just trying to incite people against me who have just been horrendous to me online, including him, who has multiple false accounts, fake accounts that leak information that only he would have about me. And like I said, every Reddit post just has my full name. He lists my full name everywhere.
Okay. Other than through legal counsel and court proceedings, should there be any path of communication that's left open between you and Mr. Echard?
Just the paternity case. No, I guess there's nothing else that needs to be left open.
All right. And the North 69th Street address in Scottsdale is your home address?
Yes, it is. Yeah.
And then do you know whether Mr. Echard uses or has access to firearms?
I do not know. I don't believe he does.
All right. And then I know that you have language here that says, and I'm looking at your proposed form of order. It says no cyber harassment or cyber bullying under real name or pseudonyms. I'm fairly certain I understand what you're asking, but can you explain what you're asking the court to order if I were to grant your petition in terms of cyber harassment or cyber bullying?
Yeah. I guess him not posting on Reddit trying to incite people against me, or he just did this this Instagram post where he's trying to incite people against me by saying that that these test results are back when they're not.
Hey, Carol Cooper.
Name calling on
the book
on
fair.
Reddit, and he sent my attorney a message from an email address saying,
honestly, I think, and this is the problem, and we're going to see this at this next one that we're about to play, but it seems like the moment that especially maybe a male judge hears that a guy was denying you were pregnant, you automatically kind of jump towards, oh, like, what a dick, like probably slept with her, doesn't want to hold, man up to his actions and the ramifications and consequences, and feels bad for her. And I hate that. I hate that so much.
Laura Owens liar at gmail.com. And
how do you know that's
so
him?
I guess not that, like just I just want him to kind of just stop all of this. I want him to just, be a truth teller and stop harassing me. I guess I'm not explaining it well.
Okay. I'm going to type some things into your order. Let me tell you, Ms. Owens, I'm going to grant your petition. I'm going to issue.
Why? And again, just to reiterate, truth teller stuff. Just to reiterate, they usually do more times than not. They will grant an ex parte order because that's just an order temporarily granting them the protection until the actual hearing with both parties. But again, after her first petition was denied, and if you're going based off just the new claims, everything she's claimed is not attributed to Clayton. It's to these pseudonyms and alt accounts that you cannot prove are Clayton.
An order of protection that includes you as a protected person, and include your home as a protected address, leaving open only the path of communication that Mr. Echard is not to have contact with you except through legal counsel and court proceedings. And then I'm gonna work on some language here for a moment that addresses the issue about what's going on online. And then I'm going to read that to you and see if there's anything that you wish to have changed. So give me a moment while I do that, and then I'll read to you what I have. Okay.
Javier. Oh, what a tangle web.
Okay. I mean, he can. I don't mind if he emails because we don't have.
I'm sorry. What, ma'am? Well, I'm sorry. What? So you just went in and said I need an emergency order of protection, and the judge says your proposed order. Yeah, I'm gonna have to, fix this wording and make sure that you do not have communication outside of legal proceedings and counsel. And then Laura stops him. Okay, but wait, I don't mind if he emails me. Like, essentially, what I want you to do is stop him from being able to post the truth on social media. But as far as actually, if you could just do a little switcheroo and force him to talk to me, that would be great. Thanks. Like, what in the Elmer Fudd are you doing, lady? That should have told him right then and there. What? That's like the opposite of usually what people are asking me to do. And thank you, Jean. MJ's got so many alt accounts. She gave me this one just to use. Just kidding. I tried to have like an alt account once, and I used it once and I failed miserably. Like, not to do anything mischievous, actually to send a meme, funny ass meme too. And I attached like all of my legitimate full name and information to it. So that was the one time I tried to do something anonymous, and I was like, I can't. I failed, but thank you so much. Be careful with my Jean Lasker account. Yeah, I literally, I was like, oh yeah, I'm gonna try to make this funny ass meme and not get my name attached to it. And I literally attached more of my information that I've ever shared on social media before. So I was like, not doing that again. Nope. Nope.
Counsel in the paternity case. Neither one of us does. I just basically, I just want him to not, be that character assassination or anything like that.
Okay, but in this day and age, people have different opinions about what's character assassination, and that's what
Yeah.
I understand what you're saying, and I believe
Yeah.
that you have a particular idea about what you're saying, but to use that term, or cyberbullying or cyber harassment,
Right.
those are amorphous terms that don't have strict
Oh,
boundaries. So I'm gonna work to communicate that. But you want to leave open a
Yep.
path where he can email you regarding the paternity case?
Yeah, just because we don't have counsel.
Okay.
He's just doing the proposed order. Silent.
Defendant shall have no contact with plaintiff other than as outlined herein, and shall not cause others to contact plaintiff other than as outlined herein. And I'll read that to you in just a moment. I have also included language that says defendant shall not communicate or post untrue or harassing comments regarding plaintiff online, including but not limited to social media, and shall not cause others to communicate or post untrue or harassing comments regarding plaintiff online or otherwise. So I've tried to leave that vague, and I've tried to leave it such that it doesn't interfere with individuals' constitutional rights. With that and with that understanding, is there anything you would have changed about what I just read to you?
I think that's absolutely perfect.
Okay. And then
Me too, Samantha.
the
Same
outlined is herein. I'm going to read that to you in just a moment. Let me just make sure I didn't miss a word or anything here.
This pretty much, there's 2 more minutes of it. This pretty much just outlines the order, but I'm going to play the next one now where Clayton and Laura are both there, okay? And Clayton gets to give his side, and unfortunately, and again, this is why if you can have an attorney, please have an attorney. Oh, actually, no, first I want to play this 911 call she placed the same day, like essentially the moment. This is how nasty she is, okay? As soon as she got that temporary protection order, what does she do? She calls the Scottsdale Police Department and says he violated it, okay? So first I want to take a listen to that, okay? This is the same day. See, October 6th, 2023, same day. So she essentially hung up that phone and called. He wouldn't have probably even been served. He wouldn't have been served yet, which it doesn't go into effect until they're served.
Scottsdale, please.
Hi, my name is. I got an order of protection granted a couple of hours ago, and the person's already violated the order.
Okay.
The judge said I could call.
Okay. Well, it only happens once they've been served. Have they been served?
There you
go. No, but he said that I could call before, and if I had a copy of it, and I do have a copy.
But it doesn't go into effect until that person's been served the order.
Oh, okay.
So until that person's served.
You sneaky little, I'm not going to say it. How does he know he's violating an order if he doesn't know an order even exists, number one? But it just goes to show she grabbed this just to shut him up and weaponize it against him. It is so messed up.
You can't violate it.
Okay. How will I know when he's been served?
I wish they probably would let you know. I think there's on the form it says to advise you when it's been served.
Okay. Is it possible for me to just make a regular report then?
reference what?
It's harassment, and it's pretty bad.
What did he do?
Well, he's a very public figure, and he's posting falsehoods about me online, and it's just getting tens of thousands of comments, and I'm getting harassed by everybody.
What address are you at when this happens, or do you live in Scottsdale?
I do. I'm at. Or do you want my address? I'm sorry.
Yeah, please.
It's.
Unit number?
No unit.
Okay. And then what's your name?
Oh, sorry.
Yeah.
And what's the last name?
Owens, O-S.
And a phone number for you?
And there's so many got away with it.
Okay, and the other party's name?
Clayton, C-L-A-Y-T-O-N.
Mm-hmm.
And his last name is E-C-H-A-R-D.
Okay. And he's by doing social media posts?
Yeah, social media.
Okay. All right, I'll put a call for service in and have an officer call you.
Okay, thank you so much.
Bye.
How unbelievable. Like, just got the order.
Got the police now.
Just got the order. Okay. And already trying to get him arrested. He hasn't even been served. So now we're going to go to the October 25th hearing. Okay. Probably won't get through the whole thing today because it's almost 2 hours. But this is the actual OOP hearing. And so Clayton will be there this time and be able to present his argument and his defense. And we're going to see the lawyer that Laura had during the injunction against harassment. Okay. So here we go.
What happened on 9/21?
Oh, hold on. It picked up where I left off. Hold on.
Ms. Owens, counsel, do you want to make your appearance?
Yes, Your Honor, Attorney Joshua Lopez representing.
Why is it so low?
Laura Owens, who's present before the court. Seems am I right?
Thank you. Nobody has to stand up again, okay? Not even you, all right? Ms. Owens, please tell me your name and date of birth.
Laura Owens, 5/14/1990.
Thank you. Mr. Echard, sir, tell me your name and date of birth.
Clayton Echard, 4/29/93.
Echard, thank you. All right, I'm going to administer the oath. Do you both solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes.
I'm just before we start.
Yeah.
There was a motion to allow plaintiff to appear by phone. I denied it last night. And then there's another.
There was, listen to this. There was a motion to allow plaintiff Laura to appear by phone, like just like the emergency one. It is this is your order, your petition that you filed in your territory, your courthouse, and you want to appear by phone? No. Oh, no, I object.
Any objection? All objections.
No.
Yes.
No, sir. I mean, John, no.
It is. It's unbelievably off the charts.
Motion from the plaintiff this morning.
Thanks, Holly. Thanks for making my Tuesday even more interesting. It's like watching a train wreck. Yay, I know. Oh, that's so funny.
The hearing in, we had a hearing yesterday. Mr. Echard, was the petitioner in that matter and an injunction against harassment in that.
Okay, so there was the hearing yesterday in context of this for the injunction against harassment. So that first part of Clayton versus Laura that we watched, this is the next day after part 1. This was a mess.
That was available for individuals to access that hearing online via the court's website. My understanding in order protection hearings that online access is not available.
That's what I was told by staff.
Okay.
So I'm just gonna deny it as moot.
No problem.
Your second motion,
Okay,
which
thank
is
you.
to request that the hearing be closed from the public. Well, that's a non-starter pretty much.
Okay.
That's really rare.
I understand.
I mean, it's public hearings. But at the same time, or that the hearing be closed from watching online. I'm told by my staff that we don't do that. It's just not set up to do that today.
Okay, thank you.
You're welcome. So.
Court closed. You know where else we heard that recently? With the Lauren Matthias situation.
Let me just give this to you so you can file it after the hearing. There are real kind of unusual rules attached to orders of protection. So. All right, I've read the petition. Folks, the way I run all of this is just, where do you go? Is he down there?
Yeah, let's plug it in.
All right, the way I run all of my hearings on orders of protection is they give us a time slot of 45 minutes. So I always start out by saying to people, each side will get 20 minutes to put on their entire case, and that includes me looking at any exhibits you might have. And the way the sequence of events will be that the plaintiff gets to go first. I want to hear her view of the matter, her story, and she can include her exhibits, as to supplement what she's saying. And then after plaintiff is done testifying, then I'm going to invite the defendant, Mr. Echard, to ask questions of the plaintiff if you have any. You don't have to have any, and I don't take any inference from whether you have them or not. So once that process is done, then I'm going to invite the defendant, Mr. Echard, to tell me what happened from his point of view. And we'll consider the exhibits that he has. And then I'm going to invite counsel for Ms. Owens to ask Mr. Echard any questions if he has any. Again, you don't have to have.
I say go con.
And then finally, here's the other one. And then finally, I'll give Ms. Owens an opportunity to sum up or to do a rebuttal to what Mr. Echard said. Okay, so it's a really good idea not to use up your whole 20 minutes in your initial presentation. And the defendant too, if you want to.
It is for me, Joe.
Try not to go over your time. If both of you've been efficient and you need more time, and I think we need more time, we're going to do that. But I want to make that judgment when I get there. I don't know. It depends. If you're not efficient and you're going off on different things that don't really have any relevance to this, then I probably will not allow more time. So with that said, I will invite Ms. Owens to put on her case. You've got 20 minutes, Mr. Wilson.
And Your Honor, could I do a brief opening?
Of course.
Okay. Let me just start my timer. The evidence will show that Lauren and Clayton had a romantic relationship back in May of 2023. Lori became pregnant with Clayton's twins. They are due in February of 2024. Since that time, Clayton has disputed that Lori is actually pregnant or that he is the father of their unborn children. Clayton has made it known to Laura that he hates her, and this has caused him to post harassing information about Laura to his hundreds.
Again, and I know it's really low. It's really low for me too. It's just the video. But he's allowed to say he hates you. You can't, again, that's not harassment. Thank you, Linda, for the super sticker. I'm reading the subtitles too. I wish I could make it higher. I didn't realize it was this low. I haven't watched this full hearing yet. I'm doing it together with you guys for the first time.
The thousands of followers online. The evidence will show that Clayton has committed domestic violence within the meaning of the statute in multiple ways within the past year, and that there is a likelihood that this unlawful conduct will continue into the future if this order of protection does not remain in effect. We will request at the end of this hearing that it do remain in effect. Thank you.
Hi, Kiwi.
Okay. Start by establishing the relationship and then including whether they've ever lived together, and then take it from there.
Yeah, please do establish the relationship.
Laura, how do you know Clayton?
He was my realtor to start with, and then we were intimate one night in May of this year.
And when you say intimate, is that a sexual relationship that you had with Mr. Echard?
Yes,
Where was that?
that was at his house.
And is his house located in Scottsdale?
Yes, it is.
Here in Arizona?
Yes,
And within Maricopa County?
yes.
All right. And after that encounter with Clayton, was that back in May of 2023?
Yes, it was.
And what happened from then?
From then, well, we have a real estate transaction that went wrong. He ended up getting in trouble with the ADRE for not submitting my offers. But that happened a few months later. After that, on June 1st, I found out that I was pregnant, and I figured he probably wouldn't believe it. So I went to urgent care, to Banner Urgent Care. And
Now, ma'am, little slips like that I find very interesting, and verbiage, okay? Why would you automatically think, Clayton won't believe me? Why? Is it because you have gone through this 2 times before where you faked pregnancies with men who didn't believe you? Why, like under normal circumstances, I don't think a woman would go, oh, he's not going to believe me, so let me go and get a test done at the medical laboratory. Or maybe it's because you didn't have sex. Well, to Laura, it is neat noodle. Obviously, it's an urgent care walk-in type situation. Yeah, he won't believe me is the first thing you think of. Maybe it's because you guys never had sex. That would make sense.
There by a doctor, and then I told him.
Okay. And was there anybody that else other than Clayton that these unborn children could belong to?
No, I hadn't been intimate with anyone else since March of 2022. I was violently assaulted and raped, and I had hang-ups for a long time.
I'm sorry, what? What did she slide? What? Did she just slide in there? I have not been sexually active since March of 22 when I was violently raped and abused. Is that from one of your other victims? Allegedly, right? Right? Sure, Jan. Swallowing doesn't take it to the uterus. It's true, Vicky. It's very true.
Now, since then, what has your relationship been with Clayton moving forward?
Well, I've tried to get Clayton to accept responsibility and figure out a parenting plan with me. But that's really been it. It's not like it's been a dating relationship. And yeah, I mean, we've communicated via email for the most part.
Okay. And has he posted anything online or sent you communications indicating his hatred toward you?
Yes, he has.
Please avoid the leading question.
Has he sent communication to you?
Yes.
Okay, and what is that?
Judge, look at her face, though. Please avoid the leading questions. The questions were essentially you're providing the answer while asking.
Has he sent communication to you?
Yes.
Okay, and what is that in regard to?
That has been in regard to how he feels about me, and how he hates me, and that doing this to him, meaning making him be a father, would be his idea of being in a living hell. He's told me he wanted 100% custody, despite also claiming I wasn't pregnant. But then he said I should take 100% custody. He also said that if thought it was just one baby would be put up for adoption, and then
Again, you don't have to like any of that if it were true, right? He's allowed to say all of that, though. And this is where we see the court system being weaponized when someone doesn't like what another person is saying. He's allowed to say everything he just said. Inverted uterus.
he said that he wanted me to have an abortion.
Okay, so I'd like you to turn to Exhibit 1. What is that?
These are text messages from Clayton to me, just threatening, really, saying that I needed to back off on, basically not saying I was pregnant, and then he referred to, yeah, he hates me. He demanded he talk to my mom, which he did, and then he said people like me needed to be held accountable if I was lying about being pregnant, which I clearly was not. He said that when his mind is rooted in anger, it doesn't sway, which I took as threatening. And then we have about him saying about an abortion or adoption.
Now, these text messages, are those from Clayton to you?
Yes.
And were those within the past year?
Yes, they were.
Since May of 2023, when you
Yes.
became pregnant?
Yes.
Okay. What happened on 9/21/2023, as you stated in your petition?
That was when Clayton posted on his social media, that had a big following, that I had two identical cases, and tried to present me in a very false light to his followers.
Did Clayton ever indicate to you that he wanted you to prove to him that you were pregnant?
Yes.
And did you take steps to do that?
Yes, I did. I went over to his house and took a test he bought in front of him, and I peed on a stick in front of him.
Okay. Were there other things that you did to show Clayton that you were in fact pregnant?
Yes, I invited Clayton and his family to go to my first ultrasound with me, which his family.
I love the way she words this. Yes, I invited Clayton and his family to come to the first ultrasound with me. What she is leaving out is that Clayton had blocked her and she had repeatedly given ultimatums and an insane amount of emails, dating contracts, to the point where she decided to go through his family and contact them. She makes it seem like they just had this open relationship that already existed. No, that's not the case. Hi, Kamisi.
Didn't respond, and he didn't go. And I asked about taking a prenatal paternity test, and this has been an issue with him and I going back and forth as to who to take the paternity test, but I proved I paid for it in August, and he did not show up for his portion. He didn't schedule it.
So did you ever send him a video showing him that you in fact were pregnant?
Yes, I did.
Okay, I'd like to turn the court to Exhibit 17, and Your Honor, I'd like to admit Exhibit 1 into evidence.
Any objection to Exhibit 1, the text messages?
Yes, I'm trying to pull it up here. I had it sent via email. I would just simply object on the basis that I think there's missing context. It's a text message that where no context is provided. And considering the circumstances that I do not believe her to be pregnant, I believe that I'm the one being harassed. So I don't believe that I ever have harassed her.
Okay. I think the context can be shown when it's your turn. You can fill that in. Okay. So overruled, I'll admit Exhibit 1. What's the next one?
Your Honor, I'd like to prove that, and I'm skipping around here because of the limitation of time, but Exhibit 17, Your Honor.
Okay.
And I can bring it's a video, I can bring it up.
What?
The court doesn't have a video in hand, so that would be it's going to be the last exhibit on the list, which would be Exhibit 52.
You don't have a video in hand?
No, I don't have a video.
Did you give her a thumb drive?
I did give them a thumb drive yesterday, Your Honor.
Okay, so if it's in there, it'll be Exhibit 52 because our exhibits are numbered
Did you give Mr. Echard a copy of the thumb drive?
Well,
All right.
she's doing the talking right now because he is asking. She is under direct examination at the moment. So he is asking her and she is testifying.
Tell us what's on it to first, so Mr. Echard just doesn't land in his lap, and he has a chance to.
No, Pam.
What is this? Lay a foundation for this video. You've already talked about the fact that that she offered to all the stuff that she did to show Mr. Echard that she really was pregnant, paternity test. She said he didn't show up for it, all that stuff. So what is this a video of? Is it him or is it somebody else on the video?
What is the video of Owens? It's of me showing that I was pregnant. It was a video of me.
No, go ahead. Go ahead, Laura. Explain the relevance. This is a video of me and my baby bump. That was not ever a baby bump. It's me showing my stomach, Your Honor.
Did you send that video to anyone else except for Mr. Echard?
The video on 9/20.
The video that you just disclosed regarding your pregnant stomach?
No.
Okay. And did you ever find any harassing information regarding that video online after you sent it to Mr. Echard?
I think you're referring to a different exhibit, actually. The Halloween one?
Yeah.
Because that was one was a video, one was a photo.
Did you ever send?
This had an image. So exhibit 11 is a screen grab of a Reddit
Yes.
saying
This is the day after this protection order was the day after that first part of the injunction against harassment took place. So the day after she was rubbing that moon bump and all up in the camera and asked that judge, can I just show Clayton I am actually indeed pregnant?
Various costume contests, and it's me turn showing my stomach, and it's me holding a sonogram of our son that only he had possession of. So he clearly.
Oh, whoa. Where's that one? A photograph of your baby bump and you holding a sonogram of our son. Notice how she says that. Yet in the future hearing we already watched, you said you never sent him. Okay, all right. I'd love to see that exhibit.
Of me, which obviously was offensive.
So in exhibit 11,
Yeah.
our exhibit 11, that is a picture that you had sent to Mr. Echard.
Yes.
You did not send that to anyone else, or did you?
This was sent to somebody in the press, but they weren't supposed to publish it. But the sonogram that I'm supposed to be holding was.
This was sent to the press by me, but they weren't supposed to publish it. But I'm now saying that this is insanity.
That was not sent to anyone else other than him.
Okay. So was he the only one that would have been able to post that?
Yes, he was.
Okay. Your Honor, exhibit 11, I'd like to admit into evidence.
Any objection?
That's the one with the picture right there.
Yeah.
Sure, you can get that.
Okay, thank you. Exhibit 11 is admitted.
Okay. Moving forward, let's talk about.
I wonder what she's whispering.
Well, tell me, what channel did this have any connection to her, or besides her image, her face is not shown. So So does this identify her in any way?
So it does because of his image. People on Reddit, there have been just thousands of people who have posted on this about me, and so this was just another post about me, but I've been identified on Reddit.
No, but how can anyone identify you in it? Again, I wish that judges wouldn't allow her to answer the exact question you're being asked. I can post a picture of someone pregnant right now and say, yup, this is Stephen Callie in the chat. How can you actually show that that is you? How can it actually be identified as you?
And this image was...
Sorry, how is this before? So this is right before he had a lawyer. So again, this is the day after that first part of the injunction against harassment where Clayton didn't have a lawyer, where she was rubbing that baby bump. This protection order hearing the next day. And then between now and that second part to that injunction against harassment before that bomb-ass female lawyer comes in. So he didn't have representation at this point.
Shown somebody had gotten this image on Reddit, and it was with my face. They just took it out for the purpose of this post.
Now, is it your understanding that Clayton had posted online regarding misinformation regarding your pregnancy?
Yes.
Okay. And what happened after that?
So Clayton posted a video on 10/6 on his Instagram that I believe we have, and it was him saying that there had been test results back from the lab, from the prenatal paternity test, saying that the results came back and there was little to no fetal DNA, and that he wasn't the father, and like it's a great way to start off the week.
Now,
so it's not day 2 of that hearing, Joe. It's the next day, but this is a different hearing. This is the protection order that she had applied for earlier in October. It just happened to be, and if you guys remember that part of the injunction that we watched, they said they have another court date tomorrow. That was this one. So separate cases, but the next day.
Was the paternity test over at that point?
No, it was not. It still is not over.
Is it ongoing?
It's ongoing, and that's what I was told by the lab. They said that they got a diluted sample and that they needed me to submit a new sample, that there was little to no fetal DNA within that sample, but obviously not that there wasn't within me. It was some issue with transit, so they had me come back and take another test.
After Clayton made that post, what happened in regard to his fans and followers?
His fans and followers went absolutely wild on me, harassing me, telling me that that I wasn't pregnant or that I had filed this false case against Clayton. And the press ran with the story we have with Exhibit 12.
Is that post that Clayton had posted online, is Exhibit 16 that video?
Yes, it is.
Okay, Your Honor, I'd like to move into evidence Exhibit 16 and then publish it for the court.
All videos are going to be on Exhibit. They're not separated.
Exhibit 52 then, Your Honor.
Okay, any objection to my looking at this video that he's?
No, I made it public, so.
Okay, then go ahead. That's admitted then. So we're gonna watch it over here?
I can put my computer wherever is best for the court to.
Well, why don't you go ahead and put it on the witness stand and I can see it there, and Mr. Echard, you're welcome to come up and look. You probably should.
Well, I can, I mean, I know the video.
Come on up anyway. That way you're not gonna feel it.
You know what we need on a Friday? We need some good news. Who's got the good news today? I got the good news. What's that good news, Clayton? Well, test results came back early, and they said little to no fetal DNA present. Let's go, baby. We knew, I knew that was gonna happen. Thankfully, 5 months
So again, it's just a story he posted on his Instagram, I believe. Do you blame him? Comes back little to no fetal DNA, which is what he's been saying from the beginning, is she isn't pregnant, but he's allowed to. He's allowed to. You're trying to limit his free speech. Oh, yes, that does happen, Ping Pam.
Miss Owens, did you ask Clayton to take down that post?
I did, yes.
Were there other posts that you asked Clayton to take down?
One was an Instagram story that he had that expired after 24 hours, but he didn't take it down.
And what was that Instagram post referring to?
That was saying that I had posted, I had made 2 identical allegations against 2 other men.
Okay. And in that video where he indicates that the results came back early, was that true?
No.
Okay. Were the things that he was posting online causing, or was it known to him that it was causing you to be harassed by him and his followers and fans?
Yes, it was. I made that very clear. And also the news headlines that came back were causing that as well.
And did he ever take down those posts?
The Instagram story expired after 24 hours, but the other post, no, that's still up.
Okay. Now, what happened on 9/21/2023?
When was this Instagram post, by the way, that you've referred to?
That was on, I think it was 10/6.
Do you have any pictures of it or anything?
The one from 10/6, the one we just talked
Yeah,
about.
the one you just talked about.
Not the video.
The one that expired after 24 hours.
Oh, I have it on my phone, but I didn't print it on.
To an extent, Tess, as long as it's not harassment, defamation, like, again, yeah, if it's true to an extent, yes.
Well, okay, but it's not, your testimony's evidence, but
okay.
I was just asking if there was something that, so, okay, all right, go ahead.
And let me just bring it back. And
And a time check, by the way, you got about 4 minutes.
All right, did you ever talk to you know that the paternity test is not over, is that right?
Yes.
And you had, after you had seen the different posts that Mr. Echard made online, did you speak with the lab regarding those?
Yes, I did.
And when you spoke to the lab, what did they say?
They said that the testing was ongoing, and they said that Clayton very well knew that the testing was ongoing despite having posted that.
Okay, and do you have a phone call with the lab in regard to that?
Yes, I do.
Okay, and that's our exhibit 18. I believe that the court parties indicated it's exhibit 52. Your Honor, I'd like to move into evidence our exhibit 18, which is a phone call with my client and the lab.
Any objection?
No.
Okay, all right, it's admitted, and that's just audio, right?
Yes, Your Honor, it's just audio. Can I come up and
Sure,
for the court?
you can.
Okay.
You're welcome.
Sit there.
Okay, do you think he understood that the result wasn't back and I needed to take the test again? Okay. Yeah, okay, so he did understand. It wasn't like there was any misunderstanding, you don't think? Okay, okay. So I didn't know if maybe calling him would help, but if he explained it the same way he needs me, then I don't care.
I can't hear crap. but I guess this is just with the company saying that it's not definitive testing because little and no fetal DNA came back, and I'm sure a possibility is the sample became diluted. They're not going to say, "Hey, you're not pregnant." They're there just to do the paternity testing. Hi, so there's that. So this doesn't prove shit. I don't know how they allowed this in. This. I think this would kind of fall under hearsay.
Text messages, posts online, has that caused you a great deal of distress?
Oh, yes, absolutely.
And define distress for me, what's been going on?
I haven't slept well at all. I'm thinking of this all the time because I'm getting harassed by people who are even, I've had a ton of them who've contacted my parents and my brother-in-law and my sister, acting like I'm crazy and like I have done this before when I wanted to address that because I know that he's going to address that these two identical allegations. I've never had a paternity case against somebody. I do have 2 orders of protection against 2 men who I got pregnant by. The pregnancies are verified. That's we admitted that into evidence as well.
Are you pregnant?
Yes.
Okay, can you stand up for the court?
Yes.
Look at that shit. That doesn't, like, could you guys imagine? And this is what sucks, that he didn't have an attorney, because that should have been objected right then and there, because a protruding stomach does not automatically equate to pregnancy and does not prove anything. Hi, Nicola.
I'll take her word for it. Everybody seems to be assuming that. All right, you're you're out of time pretty much.
Okay, can I just ask one?
No.
Okay.
Mr. Echard, do you have any questions for the plaintiff? You don't have to have any.
I do actually.
You go ahead.
Yes.
Questions? Okay, don't argue with the vote.
Yes. Ms. Owens, did you send me via email an ultrasound video?
Yes.
You did. Okay. That was sent by you. Okay. Did you also send me an ultrasound photo via email?
Yes.
Wait. Do you guys remember the issue there? In the future trial, Laura denied ever sending him an ultrasound video. Remember, it was Greg who hacked her account. Do you remember, guys? She said she never sent an ultrasound video. The one that was proven, that was taken from YouTube 7 years prior. And that's why that attorney was like, you said you did at this hearing.
That was sent by you. Okay. Did you also send me an ultrasound photo via email?
Yes, I did.
You did. Okay.
But the video
Do you
was
have
not the video I was trying to attach for you.
So the video that I received,
Yes.
you sent that video.
Yes. That's my understanding.
You
You
sent
said that
video.
you got the video, so.
Okay. I will show the video when it's my time to present that she is that I'm speaking of. And the ultrasound picture that you sent me, or you had your lawyer show me, do you have an ultrasound report that comes with that?
Yes.
You do. Why have you not presented that as evidence?
Because
Objection, Your Honor. This sounds like health information that she doesn't have to disclose her health information to the court.
Overruled. You can answer.
I offered you a HIPAA release to get my health information as recently as I think last week and you didn't get back to me.
That's not what he asked. Again, evading the actual question. Why didn't you submit it as evidence if you have an ultrasound report, sonogram report that came with it? I offered to sign an authorization. You know, if you sign that dating contract. No. That's not what he asked. And he should have been objecting. Hi, Allie.
Did I ask you multiple times early on to take a paternity test?
Yes, as did I. I asked you the same thing.
And did you place stipulations upon that I had to date you exclusively in order for you to take that test?
For 2 weeks in order to take it early. Otherwise, I would just wait until the birth of the children was required.
Wait. Oh, no. Again, no explanation. Just answer the question that's asked. Did you not put stipulations on if I wanted that paternity test? Yeah, that if you wanted me to take it early, but then I would have normally took it. If the judge just saw that dating contract, he should have right then and there thrown this entire petition out.
Upon that I had to date you exclusively in order for you to take that test.
For 2 weeks in order to take it early. Otherwise, I would just wait until the birth of the children was required of me by law. It was if you wanted to know early.
So you're agreeing you would only take the test if I were to date you exclusively.
I think you're mischaracterizing what it was. It was so you could make a decision as to whether or not to even proceed with the pregnancy.
This is his time.
Yeah.
So I'm going to ask you to just answer his question, yes or no, if you can. If you're unable to, just say I'm unable to answer it.
Okay.
So
It's going to be tough.
Echard, ask the question again.
Yes. Did you state to me that you would only take or do a paternity test if I were to date you exclusively?
At what point?
Oh my gosh.
2 months.
Yes.
You did state that.
Yeah.
Okay. Last question. Would you agree that only oral sex was performed the night that we were intimate?
I would not agree with that.
What would you say happened?
See, I really wish he had a lawyer. And it goes, and he did a good job. Let me be clear. He was calm. There's so much emotion. That's why the judge said, don't be fighting with each other. Okay. But he was calm. And I think he did the best he could do pro se. But this is why you absolutely need counsel, because they know when to object, what to object to, on what grounds, what can be entered, what can't be entered, what should be highlighted and focused on, what shouldn't.
Only oral sex was performed the night that we were intimate.
I would not agree with that.
What would you say happened?
I explained it to you.
Shortly after this test.
Said you were insanely high that night and clearly do not have full recollection of what happened.
Oh, and don't forget, she later then claimed that she was assaulted and raped by him this night in question.
Full recollection of what happened. Do you want me to explain it to the court in detail, or?
I'm okay with that. Explaining what happened, yes.
Okay.
I remember everything, but yes, go ahead.
I remember everything as well. You were asking me when we were naked and.
Just a moment. Did you have a legal objection?
Yeah, I'm going to object at this point. I think this is a little bit outside of the scope of what this hearing is in regard to this specific. I think that I've laid enough foundation. I think it presents enough evidence to show that there was a romantic relationship. Mr. Echard actually, it sounds like he's acknowledging that by his question. Getting into the details of what sounds to be potentially sexual intercourse on the date of this, of what happened on that night, I don't think that's presented in testimony to the court?
I think to some degree, I sympathize with that. Mr. Echard, to go step by step about like, who took whose shirt off first kind of thing is really kind of beside the point. It's salacious and it's an invasion of both of your rights of privacy. But what I would think is legitimate is to say, did we have sexual intercourse, where, a person could become pregnant, you can ask something like that.
Yeah, and I guess I'll ask that directly. Did we have sexual intercourse that night?
Yes.
All right. And so you're finished with your question?
I am.
Okay, then I'd like to hear what you have to say about everything they presented. Try to focus on what they presented. Everything else is beside the point, because I'm just focusing on what they put into evidence, not their allegations, but what's in evidence.
Sure. So I would just like to state again, I guess I can address first the video that you saw. I had mentioned that I had been tortured for the last 5 months. The reason, and I did state that the results of the first round of the prenatal paternity test came back and it showed little to no fetal DNA, which is in fact what was stated to me. This led me, aligned with what I believed, that she is not in fact pregnant with 5 months pregnant with my twins, which I have questioned the entirety of this time. I have not been able to receive any evidence proving that she's 5 months pregnant with twins. When I've requested it, she has not given it to me. We did an early resolution conference last week. The mediator asked for her to make a phone call to the facility. I will present this evidence, the ultrasound photo, to make a call and confirm that she did in fact do that test there. She was not willing to do so.
Listen to that. They did an early settlement conference for that paternity case they ultimately went to trial over. And the mediator asked Laura to simply call the facility that she obtained this sonogram photograph from to confirm that she did in fact get a sonogram done there. Seems simple enough and an easy way to ease Clayton, right? And to guide these two through the court system. She was not willing to do that. Yeah, Julie, for sure. Hey, poor Linda.
She has not allowed me to speak to any of the doctors that have administered these ultrasounds, which of course has caused me to question her for that very reason, that it should be a very simple thing to do. She states that she invited me and my family and I to an ultrasound. For one, my parents live in Missouri. 2, they don't believe her. And 3,
Yes, Your Honor, speculation.
well, they don't.
Go ahead.
Yeah, they don't. And beyond that, I actually asked to, I did not want to go in person and see her, but I did ask for her to FaceTime me while she was there. She then canceled that ultrasound, and stating that she wanted her sister to be there to see the ultrasound for the first time. So, and then when it was time to reschedule the ultrasound, she then stated, I feel unsafe, and therefore I do not want you to know when I'm doing the next ultrasound because I'm afraid for my safety. So she then did not tell me when she did the next ultrasound, and that, in my opinion, was her way of getting out of being able to FaceTime me while she was there with the doctor. So with all of the times, all she has presented to claim that she's pregnant is a visual image of her stomach and a positive HCG test, which that is not enough evidence to prove a viable pregnancy. Under normal circumstances, HCG, yes, that hormone is present whenever an individual is pregnant, but that can be manipulated. The proof that she states that she submitted in prior cases was the same positive HCG test. That was it. There was never an ultrasound or report, or a OBGYN or a doctor willing to corroborate her story. And that has been the case as well. She mentions in the previous cases that they are not exact. And I would state that, sure, they're not exact if we're going to be very specific with our words. But what I can state is she's claiming that she's 5 months pregnant with my twins after we engaged in not sexual intercourse, but we had oral sex. She's claiming that we engaged in sexual intercourse. I deny that. She performed oral sex on me. There was no penetration. But after one time, she's claiming she's pregnant with twins. In her previous court case, which is publicly accessible, and I accessed the documents, and that's one of the exhibits that I would like to show. She claimed that she became pregnant from an individual after they engaged in sexual intercourse, and she became pregnant with twins. In the court case that I have here as evidence, there's an ultrasound that was sent to the defendant in which she states in the text message that she's pregnant with twins. So considering all of the evidence, I believe that
Hey,
she
Christine.
has engaged in repeated patterns of behavior. And with all of that being said, I do not believe that she's in fact 5 months pregnant with my twins, because I have not been able to receive any evidence of proof that that is in fact the case. She would need to have an ultrasound report and a OBGYN or doctor willing to back up those claims, and she has not presented that. So that is my rebuttal to any of that. As far as the harassing messages, I don't believe I'm harassing her. I never did. I stated that if she's lying, she'll be held accountable, and I don't believe that's a threat. She attacked me as a public figure. I had a large following online. I was on reality television, and she decided
Thanks, Berlinda.
open a court case against me. This family court case. She then decided to leak this to the Sun anonymously so she could protect her name. But
Objection, Your Honor, speculation.
Yeah,
Yes, Tess.
tell me, you just said she decided to leak this to the Sun.
Yes.
What's the Sun? Is that like a tablet?
The Sun is a tablet, and I did not submit the evidence today, but I do have emails and text messages of her. Well, actually, I did actually submit something. She did threaten to go public. Yes, I do actually have an exhibit in here.
Oh.
She threatened multiple times to go public.
Oh, okay, that would be relevant.
And so I can show that. And
well, why don't we see it?
Do you want to see it now?
I think it's important.
It is public.
Good evening, Christine.
Refer to your exhibit number.
This is exhibit 16. I'm going to slide this up on the screen here.
Exhibit 16. They've been reading them. Right. So this is his exhibit 16, but what exhibit would this be on? You don't know? Hold on. The problem is that there are a lot of exhibits and we have little time to put them together. So
Christine Clayton is testifying.
your exhibits. Oh my God.
I know for shiggles.
So what's your title on this one?
Threat to go public and shame me.
That's what it says?
Yes.
Got it. 34 and 30, which one? 34 or 35 do I say? Well, he doesn't know. Can I turn this on? Oh, let's see. Oh, there. I don't want a 7-day trial. Go away. Won't let me. Okay, but I can, obviously do this. So let's see. So why don't you lay a foundation for this?
Yes.
Oh, it's right up there.
Yes.
Why don't you lay a foundation? Date. How did you find out about it? Where did you download this image?
Yes.
What date? Give me some context.
This is.
He needed to show the dating contract immediately.
See the date from here. But it should be in the top right. So she says in this email.
It just says yesterday, so that's not helpful.
Okay, in this case, this was sent within the last month. As far as the exact date, I don't have it. But
Within the last month?
Yes,
Okay.
this is when probably about a month and a half ago.
Okay.
So she states in here, if you want option A, I will not post this. Option A dealt with the dating stipulation. She said, I'm just looking for support, and this would probably be over a long time. And so then she states here that she's going to put up a post, the caption, surprise, can't wait for the arrival of these two next Valentine's Day. How she knew she was going to deliver on February 14th is beyond me. But she stated on a more serious note.
I can read that. I'm just trying to get the context. You've already laid the foundation.
Okay, sorry.
Do you, and where did you get this?
This is a screenshot from an email she sent me.
I got you. Okay. So, do you have any objection to me?
Yes, poor Linda. Go ahead. Think of a legal objection.
Okay, then exhibit 34 and 35. Have you seen 35?
35.
Let's look at 35.
If it's the one, I know it's the one of the post with the two.
Echard twins coming February 24.
Yes.
All right. Okay, so both of those will be admitted. Okay, so I can read them. You don't have to, if that's okay. But if you want to read them yourself, it's your case. You tell me how you want it.
That's all right.
You want to read it? You can.
Well, I just wanted to play some groundwork, but I guess I need to.
I just closed 34.
I would like to move over to my video.
All right, let me just read this first, though.
Okay.
This is so lame. Okay.
The video, I have a USB drive here.
All right. Please give that to the clerk in one.
I gave them the copy. And I wanted to here's one for you.
No, she isn't Wolfie. Nowhere near, in my opinion.
Okay. Let me make sure I got all of it because. All right. So let me just look again at 34. 35.
What's clam diggers, Kelly?
What's the context of 35? When did you get this?
I can't. The original audio is so low. I wish that I could. I'm heavily relying on the closed captions. I'm sorry. Like, I don't know why this one is so low.
Same email.
Oh, I see.
Yes.
And this is from the plaintiff, Ms. Owens.
Correct.
Okay, got it. All right. So what do you want me to see next?
So I'd like to admit this exhibit, if possible. So this is
Also part of exhibit 52 because you put all the videos in one. So this will be defendants 53. Okay. Lay some groundwork so they can have a chance to object. Okay.
Yes.
What are we going to be looking at here?
So what you're going to see is two screen recordings. The first screen recording is showing my email inbox that this message was.
Okay. This is the big thing. This is when he's trying to show that the video of the sonogram, Laura just admitted to sending to Clayton, is identical to a sonogram video that was published to YouTube 6 to 7 years prior. Unfortunately, this judge does not understand exactly what that means. And Clayton has done his best job, again, pro se, trying to explain it. But this was a big opportunity missed.
Ms. Owens, within the message, you'll see the ultrasound video that she earlier stated she sent to me. Then the second clip you will see is a screen recording of a YouTube video from 6 years ago. That video contains the exact same video that she sent me. So you will see that these videos are identical, and this ultrasound video that she sent to me is not her ultrasound. It is a ultrasound that she stole online.
Your Honor, I'm going to object to that because The scope of this hearing is, again, whether they had a domestic relationship.
Look at Laura's face. Sorry, look at Laura's face. I don't know if she expected that. I don't know because I wasn't there in real time. I would have loved to know if she would have expected that by now.
Yeah, whether they had a domestic relationship and whether there has been domestic violence by Mr. Echard or my client, Ms. Owens. Regarding paternity, regarding her pregnancy is, and regarding what maybe she said to him, isn't within the scope of this hearing. What this hearing is in regard to is whether, again, they had a domestic relationship and whether he has harassed her by putting things online when there's now a court order forbidding him to post false information. What he sounds like he's trying to show, again, it doesn't have, that's outside the scope of what this hearing is about.
I will consider your objection in deciding what weight to give the evidence. But, and to some extent, I think there's some validity to what you're saying. But I'm going to give Mr. Echard an opportunity to basically what he's trying to do, and I believe at least, is to show me that this is something that the plaintiff has done before as a way of, I don't know, somehow benefiting herself. And that, she created this whole situation. And
no, Your Honor. No, Your Honor. Yes, that is a point trying to be made, but that's not the point of showing this exhibit. The point of showing this exhibit is to show she is fabricating the entire pregnancy and using a different ultrasound video and claiming that is an ultrasound she received with Clayton's twins. You're missing the mark a little here, Judge.
I don't know, somehow benefiting herself. And that, she created this whole situation. And that whatever he did was some sort of legitimate self-defense to protect his reputation because she threatened his reputation. I believe that's where he's going with this. And so I'm going to decide, I have to decide what weight to give it and whether that outweighs what he's done. But I think it's legitimate to allow him to put that into evidence. So I overrule. Go ahead.
Thank you.
You're welcome.
So I will play this video again. You can see within here it says ultrasound video proof. And so I will play this video. I'm going to just pause it so I can give context throughout.
All right. Remember, let's do a time check. Oh, you're almost out of time yourself. How much do you? How long?
I mean, this video looks like 2 minutes. I do have additional evidence that feels important to try to submit.
Well,
but this is the most important one.
Go ahead, play it.
Okay. So this is showing that this is the email she sent me. She says here is whatever percentage that is, 1,000,000% a real ultrasound video.
And when did you get this?
Does it stay on here? That's just probably within the last month. It should stay up there on at the top right.
You have it on your computer. Can you magnify the view?
Let me see. I can pull up. Oh, it's going to pull up the same one. Yeah, let me pull it over here. So
or you can just look at the information, get info on the file.
This is Friday, October 6th. Yeah, it says October 6th.
All right, and is that about when you received this?
Yes.
Okay.
So this shows that this was sent from her. I just pulled up that her contact info.
Okay.
Now what's going to show, this is the ultrasound video. I want to highlight you'll say baby A, baby B, and placenta, and that's important. Again, I want to focus, here's baby B, then placenta pops up, and then it says baby A. And so again, I just want to show that this video, this shows B again, and this is the video that she sent me and claims to be 1,000,000% her ultrasound. Then it shows A. And then it comes here, it shows B and A again. And this is the end of it.
I think this is what I said earlier in the beginning when I said, I hope the judge, even though he may have meant well, but especially with social media and the internet and things that have happened, if you're not fully up to date with AI and what can be used. Look at the Kira Cousins case we just covered, and she was literally using AI to make her stomach appear like it was moving with a baby inside of it. So it's terrifying, but this is happening. And this poor judgment, I don't agree with the fact finder because clearly he didn't find the facts in this case.
Okay, so that is what she sent me directly to my email stating that was her ultrasound. Now this is a screen recording from a YouTube video that I found of a video that is what I believe to be the exact same video.
All right, now, how can you connect this video with the claim? You have to do that first. It can't just be if someone that you just found on YouTube and you're saying it's the plaintiff, but you can't prove it's the plaintiff.
I'm stating that this is not this video that I just showed you. The video that I just showed you is
Hi, Kevin.
in this video. She took that ultrasound video.
She used the exact same video.
Correct.
But I'm not an obstetrician. I don't know. How am I going to be able to tell that?
Watch it, Judge. Nobody's expecting you to be an obstetrician, okay? And I'm sorry, this is totally like a guy thing to say, in my opinion. No offense to him, but like all sonogram videos look the same. I can understand to an extent, sir, that all look somewhat the same. But if you just watch, my goodness, it is exactly the same. Be open-minded, Judge.
With the video, you can see it's the exact same, and it even says baby A, baby B plus
Kelly, I'm sorry. I'm sorry. I have to pause again because Kelly, you are 2 for 2 between the party hat with the judge and Kevin being a cat, and you're asking if he's single. So you're just 2 for 2 in my books, and I adore you. Oh, he's not even a judge. He's a commissioner. Thank you, Boots. Was the first PBO hearing in front of a magistrate, do you know? That Kelly, I adore you.
Baby B on the first one that I saw.
That was already on there.
That was already on there.
Yes.
Oh, all right. So, okay. So how do you know, besides the fact that this baby A, baby B, how did you find an ultrasound and connect it with the plaintiff?
I was searching online because I did not believe it was her ultrasound.
Did you search under her name? How did you search?
So this, I was actually
Mail.
tipped off, and this was eventually.
I do, Kelly.
Because I do have a large following, and they then said this video that was online, it found its way online because she did send this to the press. She sent that video to other people.
Objection. May I make a record?
Yeah.
Like, it already sounds like this has been available to other people. It was sent some way. I'm questioning now the authenticity of this video. I don't think that this is admissible evidence. I don't think he's laid enough foundation for this. It's confusing about how he got in contact with this video. Apparently, my client sent him something, and I just don't think this should be admitted. And if it is admitted, then I think that the court should give this very little weight.
Did you publish the first video, the one she sent you? Did you publish that online somewhere?
I did not.
And again, this commissioner is missing the ball here that, sir, the one he is comparing it to was published 6 to 7 years ago. And that cannot be altered. It is what it is. Kelly brought one clam to the party, guys. Just one sole clam.
It was sent to the press.
By who?
By me.
By you.
But it was not the same.
I'm sorry, what? Again, does he not stop and fucking ponder for a moment how she's sending all of this stuff to the press herself? Come on, Commissioner.
Video that was sent to Clayton. I sent him a sonogram and I sent the press a sonogram.
Well, the only thing that bothers me is he did make an objection that it has some validity here.
Hey,
and
Lil
that
D.
is that, you're not the
Yes,
one that
Tess.
downloaded the second video. And so it could be that they just downloaded the same video and told you that it was from years ago to some other person.
No. And this is, again, this is the problem when the courts aren't up to date with technology. No, that is not possible because it's uploaded publicly on YouTube and it is there 7 years ago. Oh, sir.
That's legitimate. It's a legitimate objection.
No, it ain't.
How can you prove, first of all, that this
Exactly.
where the second video was obtained, and how can you connect it with her other than the fact that it has the same markings?
Yeah.
And how can you assure me that your
I can assure you, Commissioner, the second video is Laura's video. You keep referring to the YouTube video as the second video. The YouTube video is the first video published 7 years ago. The second video is Laura taking from the first video and obtaining it and claiming it as her own. Yeah, everyone stay away from that clam. I don't think he does, Samantha. Sadly, Duty has not retired. Oh, geez. I hope he's, I want to say I hope he's gotten more current with the times, but he could not handle the AI video in the Kira Cousins case then.
Or didn't just send you the same video that we just watched and said, oh, this is from something that Miss Owens posted years ago in another case. How do we know that?
Yes. So the reason why I screen recorded the first part was to show you that she sent that. That came from her email.
I got it.
So that video she sent me directly. This video is, I wanted to show, that this is a YouTube video. You can find this on YouTube right now. And so it's publicly available. But she claims that this is her video.
Yeah, Samantha.
This video is 6 years old.
How do you know that?
Because it says that it was posted 6 years ago on YouTube. It shows that when it was posted.
Your Honor, again, I want to object because in any ultrasound or even like sonogram, for example, they're going to look very similar.
Oh, very similar, huh?
By just viewing something like this, it's going to show one way or the other.
He's saying that the markings are the same. But that could be because what she sent to the press is something that
No, Commissioner. Oh, he has it backwards. He keeps thinking because she sent that sonogram video to the press, anyone could have obtained it and then sent it to Clayton and claimed it was posted 6 years ago. He is not understanding. You cannot alter on YouTube the published date and the upload date. It is what it is. That's like saying, hey, Mission Impossible didn't come out in 2002. It came out in 20, to be fair, there's a bunch of Mission Impossibles, but whatever it is, like, sir, you need to understand you can't alter that. It already existed on this platform for 7 years. That's true, Tess. If we are this frustrated, imagine how frustrated Clayton was during this hearing. I could not imagine. Yeah, I do, Wolfie. That was my universe bracelet, my galaxy bracelet.
You know what? I think I'm going to sustain the objection for lack of foundation, but I'm going to admit the fact that
Welcome, Road.
the defendant at least believes that this video from his follower is truly a representation of a video.
Oh my God. No, it's not. Oh, Commissioner. It is not a video from the follower. The follower, yes, notified Clayton. Yo, you know that ultrasound video? The video she sent you? That's on YouTube. It wasn't sent like from the follower. It wasn't the follower's video. You're lucky you're cute, Commissioner. You're a cute old guy like the old man from Up. But like you need to pop those balloons and get grounded, sir.
The plaintiff sent, because of the markings are the same, and he believes his follower who took it off of YouTube. And he says that he checked YouTube himself and verified it. So that shows his state of mind, for what it's worth. Okay, but I'm going to take your word for it that this video is going to look the same as the other one.
So, but you won't admit it, but would you still watch it? Would you still watch it or no?
No, if he objected and I'm sustaining the objection, I have to be consistent with that. But I'm gonna let this, I'm gonna basically say that you're basically saying that there are other videos out on YouTube that I believe are from another case, and that's
No. No, Your Honor. He's tying, again, this video to one of her previous cases that he mentioned, not understanding it is not. It has nothing to do with Laura. Sorry for the quiver, but I'm getting frustrated, man. I'm getting frustrated now. Make sure Kevin comes with a clam for Kelly, at least, Wolfie. Yeah, he is so confident, Samantha, with the wrong information. He is so confident with the wrong information.
I will not allow it at this time. So is there anything else that you want to say you're out of time to?
So it should be my turn to cross.
No, you're out of time. You used your time, and I'm not sure it was.
You're out of time.
Mr. Echard, is there anything else that you
Hold on, wait, hold on. What did he say? You said, who did he say that to? No, you're out of time, and I'm not sure it was efficient. Who did he say that to? Hold on.
Anything else that you want to say you're out of time to?
So it should be my turn to cross.
No,
Oh, it was Laura's attorney, and he said, "Can I do my cross?" And he's like, "No. You're out of time, and I'm not sure it was used to be efficient." Oh my gosh.
You're out of time. You used your time, and I'm not sure it was efficient. Mr. Echard, is there anything else that you absolutely need to show?
Yes, there is one last piece of evidence.
All right, so what is this going to show? This is what we call an offer of proof.
Okay.
All right, I want you to focus on my question.
Yes.
What is this going to show me? Just tell me what it's going to show and say, and where did you that kind of.
Absolutely. So this is another screenshot of a email she sent me on Friday, asking me to meet up with her. This was after she filed for an order of protection.
Oh, okay.
So I question why and also she got this order of protection after I filed for an injunction against harassment. So the reason I want to present this is to show that she does not feel threatened. The reason why she got the order of protection was to try to silence me. And if she was feeling threatened, she would not ask me to meet up with her. And that's what this piece of evidence shows.
Okay. I want you to know that a person doesn't have to, basically what they're doing is they're coming on a harassment theory, and you don't threaten, you can feel threatened. That is one way to feel harassed, but it's also seriously alarmed, annoyed, or I have the statute here. Anyway, but so that's not
Anyway.
to be harassed. But in any event, I will consider this. So what is this email? You received this on Friday, okay? What exhibit is this, by the way?
Hey, Salty.
Well, I have it as exhibit 35, but I have not picked up.
How did you label it? You had good labels on it.
Laura asked me to come to sign.
51. Okay, counsel, just a second.
Look at Laura's face.
Figure out what exhibit he's talking
I wish we had a continuous stream of Laura this entire time, which we don't, but like her face is like, seriously?
Exhibit is this, by the way?
Well, I have it
Okay, counsel, just a second. I'm trying to, first of all, figure out what exhibit he's talking about. So exhibit 51. All right, and this is he's already laid a foundation saying this is an email from her to him on Friday. What's your objection?
We were only given 20 minutes. She's now 28 minutes here.
Hold on. Now listen. I will say, like, listen, this attorney is doing his job and he could only work with what he's got. Okay. But his legal objection, and I want you to understand because that is extremely relevant. After Laura filed for this order, this protection order, she reaches out to Clayton and she initiates contact and she wants to meet up. And that is extremely, extremely relevant. And so her lawyer, yeah, he does look 15. Her lawyer objects. What grounds? What lawful objection? Well, you said we would both have like 20 minutes. And like he's at 22 minutes. And he knew that this is not good. I don't want this in. And so he decides to complain about the time.
This is an email from her to him on Friday. What's your objection?
We were only given 20 minutes. She's now 28 minutes here. I haven't gotten a chance. And if I'm not going to get a chance.
So it's a time objection. I'll consider your objection in determining how much time to give you, if any. But I'm going to watch it overruled. Okay, that's your only objection. Go ahead. So I can look that up right now myself, just looking on my computer. All right. So,
Look at Laura's face. Shut that mouth you used to swallow.
last Friday, which was October 19th. Is that right?
Yes.
All right. And the order of protection was served. October 17th. So, okay, got it. So I've looked at it. She sent you an email, and the terms of the order of protection are that, as far as contact terms, only through legal counsel, only in court proceeding, and through electronic mail, only regarding matters pertaining to the paternity. Okay, well, this probably falls within that, so I'm not sure how much traction this gets you, but I admitted it and I considered it. I'll decide what weight to give it. Okay. All right. I will give you 2 minutes to cross-examine. That's about how much time I gave him. So.
Okay. You admit that you had sexual relations with Miss Owens, is that correct?
Oral sex was performed, yes.
Okay. And she's allowed to make a pregnancy announcement if she so chooses. Is that correct?
Yes.
Okay. She specifically emailed you regarding that she wanted to go to the press. Is that correct?
Yes.
Okay. And you emailed back saying that she could essentially go to the press. Is that correct?
Not entirely. She had threatened me multiple times to go to the press, and when I realized that
It's a yes or no question.
I said towards the end that if she's going to go for it.
Didn't you specifically say, I'm unbothered by it all going public, in an email to her on about September 17th, 2023?
Yes.
Isn't it true that the period for a pregnancy is 40 weeks? To full gestation?
9 months is what I'm aware of.
Okay. And so from May of 2023 to February of 2024, that's when she could expect to have her children. Is that correct?
Yes.
Okay. You did make those posts online, correct? That we previously showed in the exhibits?
Yes.
And you were made known by Laura that that was disturbing her peace because she was getting harassed by what she felt was you and third parties.
I made those posts to protect my reputation.
Okay. But you did know that her piece was being disturbed. Is that correct?
I don't understand why you're asking me this question. I was defending myself, but it was not going after her.
Did she communicate to you that her pace was being disturbed?
At some point, probably.
Okay. And so you were on notice that she was receiving harassing messages, correct?
Yes.
And she actually allowed you to appear on FaceTime at one of her doctor's appointments. Is that correct?
That is false.
Okay. She didn't allow you to appear on FaceTime?
No.
Okay. Isn't it true that you said that you wouldn't appear on FaceTime because you wouldn't, you thought that you would hire actors to pretend to be doctors?
No, that's false.
What the fuck was that face? Hold on. What was that face, Laura? Look at her.
Because you wouldn't, you thought that you would hire actors to pretend to be doctors?
No, that's false.
Look at her. Uh-huh. Oh, really? Really?
Your Honor, no further questions.
Okay, all right. Mr. Echard, I want to give you, you wanted to fully explain one of your answers, and you said it's a yes or no, so I'm going to give you a chance to fully explain that answer.
Yeah, can you just remind me what that question was again? Sorry, it was kind of a barrage. Which question?
Well,
was that about?
I honestly can't recall. There was some.
I don't know, Kimberly.
I was trying to do it quick.
3 men.
I don't know. Is there anything else that you want me to know? I didn't make a note of it, so apparently I didn't think it was all that important.
Yeah, I just want to make note that again, you had mentioned it earlier, but what I've been trying to do is prove that I've been trying to protect my image. Not once have I mentioned her on social media by name. Her name got out there because she opened this court case against me, and that's how it made its way online. So not once have I tried to harass her. She's been you could say maybe she's been harassed by my audience, but that is out of my control as I'm a public figure. What I have done is I have tried to protect my reputation. In the videos that we saw today was me doing so. I've lost thousands of dollars now because of this accusation. Everything that I do is reputation-based. Real estate, speaking on mental health around the country. I train clients online, and I have evidence. I was not able to get to it today, but I have evidence proving I am losing money because of these claims.
He needed to show the dating contract.
Okay, so
it is to you,
yeah,
of course. But,
I just at the end of it.
Your Honor, I'm going to object to you now. Like, he was given like a minute to answer the question.
Counsel, sum up in 10 seconds.
Yes. Considering the case of harassment, again, I do not believe that I'm the aggressor. I believe she is, and I think that it's baseless that she has presented this to try to put an order of protection against me.
All right. Let me consider the evidence here.
Your Honor, will my client have an opportunity to speak again? Are we going to be able to make a closing? I think there's some things that are.
Will my client have the opportunity to speak again? Will we be making a closing? You know, Laura whispered in his ear, anything but sweet nothings. It's like, let me talk again. No, Laura, you have done enough. I'm trying to figure out if they're at the end, how did this hearing continue to go on for so much longer? I don't know. Guess we'll find out.
He's clearly gotten more time to speak during this
I
hearing.
don't agree. I think that I balanced efficiency versus the time that was given, and that's my determination. So the answer is no. I gave both of you more time than was allotted, and the differences are de minimis.
I don't know, poor Linda. We're going to dig into Greg's next, but we did Mike, but I don't recall. Let me look for you. So Mike met Laura on the League dating app in late March 2016. Then with Greg, they connected on Bumble. They connected on Bumble for drinks and met for drinks on 2 consecutive evenings, June 30th and July 21st. On their second meetup, they engaged in sexual intercourse while using 2 forms of birth control. The following evening, Laura attended a group dinner uninvited. Oh, I can't wait to go through Greg's timeline. Uninvited, where Greg observed some troubling behaviors. It was this evening Greg concluded he was no longer wishing to pursue a relationship with Laura. I can't wait to go through that. Oh my goodness. Yeah, dating apps. And I really believe she sought Clayton out on LinkedIn and never had intention on purchasing real estate.
Did you send that image of, or did you post that image of the plaintiff on the internet?
Yes, Kimberly.
Exhibit 11.
No, I did not.
But it says that this post was posted by the one and only Jen. Do you know who that person is? The one. And it was taken down by the moderators of our Bachelor Nation. Is that the program that you were on, the Bachelor program?
I was on the ABC The Bachelor, yes.
And Your Honor, if you're just addressing Exhibit 11, it has to do with the sonogram.
Yeah, because only he was sent that sonogram image. There was nobody else who had it, so it had to be him. It was within hours of when I sent it to him.
Exhibit 11 is not a sonogram.
Exhibit 11 has a sonogram that in the costume, it has one that I'm supposedly holding. If you look at my hands, it has a sonogram that only he had. That's why I know it was him posting it.
But your lawyer argued that that was something that looks the same. Or that it's so small that I can't remember.
It wasn't the video that looks the same. This was actually a sonographic image that I sent to Clayton because I was concerned about the baby's profile, and that's why I also found it really offensive.
How do you know that this is the sonogram that you sent him though?
I have evidence that I sent him that sonogram. He knows I sent him that sonogram, and I have it in an email.
Yeah, but how do you know that this is the sonogram that you sent him? I'm looking, the one that's in the image on exhibit, the one that's in the exhibit, in exhibit 11. How do you know that that's the sonogram that you sent him?
Because I sent him an email with that exact sonographic image because the profile is really distinct because it doesn't look like the baby even has a nose in it, and that's why I sent it to him within hours. Within hours before that. Nobody else had that because I was concerned about a genetic defect, and I would not have sent that to anybody. That's 100% the same image.
What genetic defect? That the baby didn't have a nose? I'm not saying it's not possible, but anybody who's familiar, like, girl, tell me you've never been pregnant without telling me you've never been pregnant. The baby in the sonogram photo a lot of times looks like a lima bean, gummy bear, fucking looking in the mirror saying Candyman 3 times. It could look like a bunch. So the fact that you think it was a genetic defect, so I know I didn't send out because obviously I wouldn't want to share a photo of a noseless child, Judge. Okay, sure. Yes, Julie. I noticed that too. You're right. Yep.
Did you receive a sonogram from her?
Yes, I did.
All right. Is this your photo on exhibit 11? The lady who's image, she's got hair and she's pregnant. Is that you?
That's me.
How do you? All right. Did you send him a picture that looked like that?
Yes.
I'm not talking about the sonogram. You said that you know that this is you.
Yes, I
from
sent
him because it's got the sonogram.
Yeah.
But more importantly, you sent him this picture of you
yes.
with your body
With your body.
like that. And you didn't send that to anybody else?
No.
And you're saying the sonogram is the same as well?
Sonogram's exactly the same.
All right. So her testimony is that this picture on exhibit, and that's what I thought you said.
Yeah.
But now you're focusing on the sonogram, which kind of is a distraction almost, but I get it. You're saying that that's how it was posted with someone holding the sonogram.
Yeah.
Okay. And that's you in that picture because that's the picture you sent to him.
Yeah.
All right. Do you admit or deny that? Did she send you this picture of her on exhibit 11 where she, was wearing stretch pants, a bra, and her hair was there and she was pregnant? Did she send you that picture?
Yes, she did send that image.
All right.
I did not, though, post it online.
How do you account for the fact that it's online?
She must have sent it to somebody else. She was sending stuff to the press.
Right. Did you send this photo to the press?
I did not.
Okay. Did you send it to anybody? You're under oath.
No, I did not. And this
Just to
Great question, Samantha.
just to him, yes.
May I make a counter to that?
You've denied it. That's a matter of record. But go ahead.
I do know she made a Google Drive available for people to access, and I believe that picture.
I know it does.
She did make a Google Drive for people to access.
She denies that though. Okay, but you say that it's there. So
He denies that, sir. And see this again. Why I wish he desperately had counsel. Even the handful of emails we have seen, she connects a Google Drive and 80 million bajillion attachments to every email, blackmailing him, entrapping him. Yeah, so much for that time limit. Dude, we have another 35 minutes. That's why I'm like, what the hell? Great question, Ping Pam.
Did you publicly post a picture of yourself that's similar to this?
Not that was similar to this, no.
I'm asking her a question.
Yeah, that's why I stopped.
So,
And it was never publicly posted. It was within a Google Drive that 10 people accessed. But it was not like it was.
She denied the Google Drive.
How was it different?
I was wearing a completely different outfit, and I was I wasn't as far along. I had to submit it to the press to prove that I was pregnant.
So you gave it to the press?
But not this photo.
Oh, I see. Okay.
He was the only one that had this photo.
You're fucked. Yeah, not this one. I did a Google Drive, but I didn't send him the Google Drive he's talking about. I did send a pregnancy photo to the press, but not this pregnancy photo to the press. I feel like I need to wash the filth off in a shower. This shit pisses me off. Hi, Kathy Joe. This trial is going to be immaculate. Honestly. Superb. Fine wine. Chef's kiss. All right, sir. Ain't nobody got time for your review.
There are two of them back there. Either one. One of them has clips. It's on my credenza behind my desk.
On his credenza. It's fancy.
It'll take me a long time to read. It's in a statute that.
If I may, it's just in regard to the law, what I think applies here. Under the domestic statute.
Under what statute?
domestic violence.
It specifically indicates what domestic violence means.
Right.
And it lists, call it about 20 different ways it can be viewed. And there's
Exactly.
just,
That's kind of where I was going when you
There's
said
just
you
more
wanted
that
to interject. So, okay, go ahead. You're right so far.
okay, so I just wanted to just list four that I think like are applicable in this case. So
Yeah.
which
Which ones do you think apply?
ARS 132904.
2904?
That's correct. That's disorder. That should be disorderly conduct. And then three more, which are
Stop nodding your head, Laura, like you have any idea what the statutes even are or what's applicable. And what's disgusting is that it's your lies that are being determined if are they applicable or not. Like it's not even the truth. Again, I've said it so many times. There's no worse feeling for me than when you have to defend yourself against a lie and you're telling the truth and people don't necessarily believe you. It's a really crappy feeling. And I can't imagine how gaslit Clayton felt at this point.
132916. ARS section 1329.
Right, Pink Pam, especially after the whole sonogram debacle.
ARS section 132921.01. That's just all I wanted to.
Yeah, salty.
So tell me, I mean, I could pull all these statutes, but what is 2916 real briefly?
2916, just one moment. Use of an electronic communication to terrify, intimidate, threaten, or harass.
Right. I prepared for this hearing yesterday after my calendar was over, and that was, I looked at the petition and I thought, well, which statutes are probably going to be in play? And so I made copies of them, and I did make a copy of that one. And I also made a copy of course, 2921, which is the harassment. So 29, these are all, as he said, in the criminal code, they define domestic violence as any violation of the following statutes, and they're all criminal statutes. And so so these are what I call predicate statutes. One of them is 29 ARS 13 is the criminal code. 13-2921 is the harassment statute that's applicable to domestic violence per se. There are other definitions of harassment elsewhere, but they don't apply to this. Then another predicate offense is ARS 13, again, the criminal code. 2916, which is use of an electronic communication to terrify, intimidate, threaten, or harass, and so on. And so, okay, I got that one. So what is the other statute that you want me to, let's see, 2916, got that, that's terror. 2921, we already talked about that, that's harassment. And what's 2921.01?
That one, that was a possibility, but that has to do with, let me just.
Yeah, right? Lift up your shirt. Why'd she want to appear via telephone?
That's just like if a person has already been convicted of it and they do it again, then they can be convicted of aggravated harassment. Or they violated an order of protection.
And to be forthcoming, Your Honor, I don't believe that we were able to get in the evidence that would have shown that one. So I believe the ones that most comply are the first three that I gave you.
I see.
Yeah, he handled it very well, Samantha.
Am I able to ask a question?
Just a second, I'm trying to figure this case out.
I opened the chat up for everyone who wants to chit chat towards the end of this. For non-members. I can't believe this could ever fall under domestic violence statute. Poor Clayton. We feel you, buddy. I can't wait to look into this lawyer professing his support for Clayton after all this. I wonder if he'll be called as potential witness.
Images to the press. When you sent the images to the press, that's similar to this.
He probably didn't think he needed an attorney at this point. I really don't know why he didn't. But then once it was granted, and again, someone who's more familiar, please correct me. I don't know if it was someone from the law firm who reached out to him or he sought the law firm out that was familiar with Laura's prior cases. Hi, Abby Lane.
Well, I realize you were at a different stage in your pregnancy and you were wearing different clothes, but you still showed basically your belly. Right. Did you, when you sent it to the press, didn't you know that they could publish that?
They swore to me, it was the page 6, and they swore to me they were not going to publish anything, that it was just for them to confirm that that I was indeed pregnant.
No, yeah. I sent these photos to the press. They swore, they crossed their hearts, hope to die, Your Honor, stuck a needle in their eye. They were not going to publish it. And it was only solely to prove I was pregnant. Because once again, showing a big old belly automatically means there are babies residing in it. Duh.
But yeah, it was a different image. It was earlier on in the pregnancy.
Did you give them permission to publish that image?
No, and I made sure that I had in writing from them that they were not going to publish it, and they didn't in any of their stories or anything.
Did you give Mr. Echard permission to publish this image in Exhibit 11? No. Not the ultrasound, but the...
No.
He was sweet, some golf girl, but out of his realm. He really was.
I'm going to find that the plaintiff has met her burden.
Sorry, in case nobody heard that, because you can't hear shit in this hearing. He said, I'm going to find that the plaintiff has met their burden. Come on. Like, and it's very interesting, and I've learned this a lot recently, that each judge can really interpret the statutes the way that they want to interpret it. And that's why you go to the Superior Court and use it for appeals. And I just can't, Clayton would have had to provide case law that would have gotten this thrown out, because I don't understand. I do not understand how petitioner met their burden in this matter. I really don't. And that's me putting aside my feelings towards Laura in this situation. I don't understand how it met the burden. I don't. Greg reached out to him when it became public. Woodnick, Clayton's new lawyer, now lawyer, was Greg's lawyer. That's how he connected. Greg then showed up to Clayton's hearings. Thank you, Salty. Yeah, I look slightly pregnant when I got cats. Exactly. I must be pregnant with triplets. It's ridiculous. Like, that is in no way proof, evidence at all.
One of the predicate offenses here is ARS 13-1425, which is unlawful disclosure of images.
Wow.
The statute is really targeted toward people who send pictures of one another nude or having sex, and then they publish that kind of thing. But then there's also the second under ARS 13-1425A2. It's the photo is such that it captures the person, the depicted person who has a reasonable expectation of privacy. And then that's the first sentence. The second sentence, evidence that a person has sent an image to another person using an electronic device does not on its own remove the person's reasonable expectation of privacy for that image. And so, I'm looking at the context of this. There was a dispute as to not only whether she was pregnant with your child, but also whether she was pregnant at all. And she sent this image to you saying that this was her. She's testified that that
Wow,
was her.
TMT.
And that hasn't been disputed. And so, and she said you're the only person that she sent it to. I realize it's possible that she could have sent it to somebody else
Yes. Your Honor. Yeah, she denies that, but she has admitted the moment you are admitting to sending things to the press, how the hell can you attribute that photo being out to Clayton? That's really unfair. And to base this whole hearing off of that, come on.
And then I have to decide, would she really want to do that? Because it's not the most flattering picture that obviously when a person's pregnant, their body's changes. And it's not something that I would think that any woman would want to share. Once in a while you see it, on TV or something. But it's something that I don't believe that she would have wanted to share. And
Really?
This depiction
She went to the
not
press.
only showed her, but it was poking fun at her. And it does seem to suggest
He didn't
that
post it.
connection with it because
This is what really disgusts me. He didn't post it. You can't prove he posted it. So you are solely going off of her testimony, which again, yes, it's admissible evidence, but it's her testimony and you have to weigh her credibility to determine if you're going to believe she solely sent it to Clayton. Therefore, it had to be in Clayton who released this image. That's so unfair.
that it does say somehow it connects her to this picture because it's somehow it was connected. The Bachelor website saw that. And also it's this idea of this show holding a fake sonogram, or let's see, I have to move the statute out of the way and look at the image again. It was something like making fun of the sonogram, saying, this is all.
Oh, no ex parte here. Oh, no ex parte communications. That is not right.
The hair is similar, I guess, to the hair that she has. So I'm going to find that posting of that image, publicizing that image, was triggered the domestic violence statute 133601 does include the cite to ARS 1425.
Can't prove he posted it and falling under domestic violence statute.
And it has
Can't see her face.
that has to be shown as well. And the intent.
Yeah, go ahead. What's the intent when you can't even show he publicized it? It's the intent of others, if anything.
Just the act of disclosing it is unlawful.
Wow. He realized he can't. Wow. He realized he can't even show intent. So just the act of disclosing it is unlawful.
So that would be ARS 1425A2. I'm also going to find that it also violated ARS 1425A3. The image is disclosed with the intent to harm, harass, intimidate, threaten, or coerce the depicted person. And the intent can be filled in by Exhibit 1, which is your email to her that if she goes forward with what I understood to be the paternity claim, that you would hate her and that would not end well for her.
Wow.
Exactly what you said, but let me just get the exhibit back up again. You said in particular.
This is really messed up. Yeah, me too, Tess.
Just a moment, please. Let me just make my record, and then if you can, I'm not an appropriate person to ask questions of, but I'll listen to your question. But give me a moment to get this out. The bottom of the string says, "I hate you right now," but there was something here.
Yeah, the judge for sure is eating crow about now. Yeah, and saying I hate you is a threat. But again, he is correlating his words, which alone are not threatening, and he's allowed to say, to an action he cannot prove Clayton's did.
Pregnant because if you're not, I'm bringing this all to light. People like you need to be held accountable. You can back off now. This is all a game and I'll let it go. But if you continue any longer and it's all a lie, I won't hesitate to reveal the truth. One thing about me is when I make up my mind for good, especially when it's rooted in anger, I don't sway ever. Individuals like you that play with
Right,
people's
Salty?
emotions are the worst kind of person I've met. Many have been taken advantage of by many, and I'm sick and tired of playing nice with them. My hate is toward you and to you only. My hatred would only grow if you decide to put me through all this. I mean, on the one hand, I think it's legitimate to question whether she was pregnant. I think it's legitimate to question whether, even if she is pregnant, whether it's your child. But there are ways of dealing with that, and that would be, going through the paternity case.
He tried.
Proving, making her, it's her burden. She has to prove that she's pregnant with your child, in order for you to be legally responsible for that child. That's the way to handle it.
He has.
It's like the common denominator in every order of protection that's affirmed is that people have sometimes really legitimate feelings and rights. Like I feel you do. But at the same time, they go about it though. They go about vindicating those rights by taking matters into their own hands.
He
and using
didn't.
self-help remedies instead of dealing with it through the courts like you're supposed to.
He has.
And that's where you went wrong. Not that you had.
No. Oh, I'm sorry. And listen, I understand he didn't have all the information, but this is really, really frustrating. He did. He was. He had. He had filed for the injunction against harassment after she filed the paternity case in the family courts, and all of the DNA testing coming back little to no fetal DNA and refusing to verify it and forcing a dating contract over his head in order to do it. So then he files for the injunction against harassment because what she was doing is absolutely met the statute for harassment. And then she filed this OOP in retaliatory. And you're granting it and you're saying he should have done everything he essentially was doing. And I cannot believe an alt account can come into this chat right now and post whatever. And you can't say that that is any one person without actual proof. Hi, Shelly Bean.
Your feelings about, questioning this or thinking that it was a fake or that kind of thing are illegitimate. You can think those things. It sounds like you might have had some reason to think that. But the way you published this photo, which is what I found, I know that you've denied it, but I'm finding that there's really no other accounting for it except if she posted it, and I don't think a woman would have done that in a situation.
I don't think a woman, this is the problem. I don't think a woman would have done that. Here's where you are wrong. And I know, Melissa, shut up, because people don't like when I share these opinions much, but just a dainty, delicate little flower, right? You can't have it both ways, right? You cannot have it both ways of, oh, don't treat women any differently. Yet at the same time, I don't think a woman would have done this. Wrong. Women are manipulative beyond belief. Okay? Men, when they fight, will dish it out, knock each other out, and then go and have a beer and get over it. Women will spend a lifetime slowly torturing you and thinking of ways to destroy you. That is why poison is the woman's weapon, right? Hell yeah, Belly May. She is making all women look nuts. And a lot are. There are a lot of nuts men too. But this whole idea of, I don't think a woman would do this. This woman would go to such extreme lengths to fabricate a pregnancy. She is wearing a moon bump in this courtroom right now. So enough with that shit. It's like still, and again, he's a little bit older, so I get it a little bit, but like this idea of you can't question them territory. Wrong. She's claimed rape against Clayton, pregnancy against Clayton. Like when she put her suicidal attempt, which bullshit, never happened, in my opinion, onto Clayton. When does Laura get held accountable, or any other woman who has done this? Enough. You don't think a woman would have done that? Fuck yeah, she would have, and she did much worse. Time to wake up.
If I before I went on a diet and I took a picture and sent it to somebody, I wouldn't want that picture. It's unflattering. I wouldn't want it. Yes, it's focused on a woman here, but this is something that most humans don't want to have unflattering pictures of themselves.
Really? Then why would she send it to the fucking press? And thank you for saying she looks unflattering. We were all thinking it, but you said it.
And so that's my reason for making my decision.
It's a poor shit reason.
So, and the intent is proven by Exhibit 1.
No, it's not.
And I also find that that's a violation. By doing that, that you violated ARS 13 the harassment statute.
No,
13 2921A.
God, more time has been spent for him looking up the statutes.
Communication with another person by verbal, electronic, mechanical, telegraphic.
So have I, Samantha. So have I.
And another one is surveys or causes another person to survey the person. I think that is.
I hope so, Pink Pam.
Survey may have to be in person. It's not. That term can mean following somebody. It could mean following them and harassing them online. I mean, today, harassment online is just as bad as, almost as bad, possibly worse in some cases, where, it can be magnified.
Oh, poor Clayton.
That's something that I think,
yep.
To me at least, just looking at the regular word survey, it doesn't have to say publicly survey as it does, and like subsection A2, for example, that requires public, that you're following another person in or about a public place.
Him following her?
That doesn't apply here.
No, it doesn't.
Subsection 3 does, because it doesn't have those limitations about being in public or in person. And then I'm also, counsel had suggested that ARS 132916 is applicable. Use of an electronic communication to terrorize a person.
To terrorize her.
This one, I'm not sure. Let me look at it.
He needs his justice. Clayton needs his justice, just like Greg and Michael needs theirs. This is a dangerous woman. I'll eventually get it. Women.
I do not find that applies. One of the subsections. Oh, hold on. There's one other thing.
Woman.
I'm looking at 2916, the terrify, intimidate, harass statute. Subsection 4. It's unlawful for a person to knowingly terrify, intimidate, threaten, or harass a specific person or persons by doing any of the following.
How did he do that?
I think 1 through 3 apply. subsection 4 might.
Sir, you said yourself when he introduced the evidence showing that she wanted to meet up, and he said that she clearly didn't feel threatened, that you said, oh, well, this isn't just about feeling threatened. It's about annoying her and stuff like that. So now you can't bring back the feeling of threatened when you want to use it to her advantage, when you yourself said it wasn't about feeling threatened. Yeah, I don't blame him, Salty, for feeling absolutely defeated. He was.
So let me read it. Without the person's consent and for the purpose of imminently causing the person unwanted physical contact, injury, or harassment by a third party, like the following, for example. Use an electronic communication device to electronically distribute, publish, email, hyperlink, and make available for downloading the person's personal identifying information,
Hey,
including
South Florida thrifter.
image of the person, and the use does, in fact, incite or produce that unwanted physical contact, injury, or harassment. This paragraph also applies to a person who intends to terrify, intimidate, threaten, harass an immediate family member of the person whose personal identifying.
They do. Everyone remembers the accusation. Nobody remembers the retraction. It's a very true statement.
Intimidate or harass her family, although that might have been the effect of it. I don't think that he had that intent, but I think that he had the intent to do that to you. And so I'm going to find that another applicable statute, which is another predicate.
Yeah, you can unring the bell test.
Is ARS 132916A4. And so those are the reasons for my ruling. Brady does not apply because my understanding is that the parties never lived together, right?
Yes, we did not.
So that's required by Brady. So you're not going to.
It for sure does, Samantha. Sets all true victims back.
How you use those. And you've never threatened, personally told her that you're going to harm her. It's just that this, it's almost like you can summon a tsunami with your followers, according to her testimony. Does the plaintiff want, I'm going to answer, I know you have a question. So
Ready for this?
Give you a chance to ask it. But before I get there, I want to find out from you, is there anything that you want me to do to modify the order of protection?
I think, we can still have communication about.
I'm sorry, what? What? I'm sorry, what? Did she? You want to have communication after all that? After you made him sit there as this commissioner, bent your testimony to fit within the statutes to grant this protection order, to then turn around and say, well, I still want contact with him, but I just want to limit his free speech and not allow him to share anything publicly. Oh, my goodness.
I think, we can still have communication about paternity. My main concern with him is just that he's going to be posting untrue things that are going to cause people to harass me. I'm not afraid he's going to physically harm me. My concern is more that, but I still think we need to talk about the paternity case because we're both unrepresented in that.
That's fine.
Yeah.
Yep, coffee and skeletons.
I think that the order of protection itself is broad enough to encompass this idea of continuing to incite people to bother you. And so I choose not to put anything on there because it would be really difficult to write. Why? There are First Amendment concerns here that I don't want to say, don't tell any of your followers sure that that's probably overbroad. But I would be working probably futilely to find the right balance of language here. I'm just gonna leave it. All right, so I'm not gonna amend the order of protection. Okay. All right, now,
Whose baby is that?
another question for me. I would, let me just finish.
Hey, Chief.
And I'm gonna be glad to try to at least answer your question.
Yep.
Okay, ask.
Yes, and thank you for waiting patiently on that.
My understanding is that this order is going into effect because the belief is that I was the only one that had access to that photo. If I'm able to prove, which I believe I can prove, that she had sent it to someone else, am I able to get an extension before this ruling?
No.
Because I do believe I can prove that she sent it to other individuals.
Okay.
So I guess my question is, how do I go about, because again, my understanding is that's what this is hinging on, and I do believe that I can get credible evidence that she sent this to another individual. So if I'm able to get my hands on that, would that not reverse the ruling?
No, well, first of all, I'm gonna rule now. I do not, this is the time for the hearing. And these are, this is, I don't think it's appropriate here to hold the case open until you can come back with more evidence. So, no, I would choose not to do that. I also, and I know that that was my main focus.
Yeah.
I also believe that you talked with your followers about this and that
He's allowed to.
she testified that you had made comments about her and how you don't believe her and that she's a liar.
She is.
Your fan base. And I also believe that that is something that can be added as reasons for my decision under the harassment statute. ARS 2921 1A1 and 2.
He's not inciting them. Again, this is the internet, man.
She came to me for an order. Well, I don't think I'm allowed to say that. I think if all that.
Oh, okay. So the first, okay. So the first petition she filed, she was in front of him. That was denied. Then she filed the second one, which we just listened to prior to this. And that commissioner explained you can't include, because of res judicata, you cannot go and try to litigate the same claims that you filed and that were already ruled upon. So you need to focus on the other claims you put. Well, he was allowed to. It's not that he wasn't allowed to. She would have filed ex parte hearing. But if she would have done that anonymously, meaning if it failed and the burden wasn't met, that she wouldn't have, the other party wouldn't have been notified. That's allowed, but I don't think he was supposed to bring it up because it didn't meet the burden. So he did mess up, but again, from what I'm understanding, it's about the ex parte original petition filed.
She came to me for an order. Well, I don't think I'm allowed to say that. I think if all that we got were a text message from you saying, I hate you, and if you do this, I'm going to be really mad.
Yes. Okay. So sorry, that resonates more. He's saying, he was going to say, she originally came to me for an order before me, and she didn't include the evidence that she included today. So, for example, referencing that original petition, if she only included this text messages saying, I hate you, X, Y, and Z, that wouldn't be enough. Hence why he didn't grant the original one. But because she brought all this bullshit forward this time, he did. But he obviously he dropped the ball.
I mean, that could mean a lot of things. It could mean, I'm gonna sue you, and I'm gonna have attorneys, follow you to the lawful ends of the earth, to the extent that the law allows. That is, that's scary, but you have the right to do, you can say it once.
I don't know. Like and please, you guys who are more familiar would know better than I do. I'm just referring to the legal system. It seems to me like he's referring to that original, again, the one that we listened to right before this hearing, right before the ex parte hearing for this, the October 6th ex parte hearing. That hearing referenced a prior petition that was denied. I think this commissioner is the one that she was before pleading that petition that he denied. So not necessarily ex parte communications aren't allowed outside of like an ex parte hearing. Yeah, Callie. But then even if you did, you would need to be bringing in the expert to testify to its credibility. Hi, truthfully me.
All you did, then that I wouldn't have granted an order of protection. But here, you not only expressed your intent, but then I find that you followed through with it, and you used the means that were available to you in order.
That was not proven. That is so unfair. That's her testimony. That's it.
These claims that you're the father of these children, or that I think at some point you accept the fact that she's pregnant.
Right there. Now that was not necessary. I think at some point you need to accept the fact that she is pregnant. And right there told me everything I needed to know about his mentality. He just unfortunately saw Clayton probably as a superstar bachelor who had a one-night stand with a girl and is now denying and doesn't want to face up to the consequences of his own actions. No, you're fine, Salty. I just want to, like I said, make it clear that that's allowed if I go in and I file for a protection order tomorrow, there's an option to have an ex parte hearing or not. What that means is if you file ex parte, that means the threat is so imminent, the harassment is so bad, I am asking to have an ex parte hearing essentially right here or now, or at the next motion hearing date, because I can't wait until 2, 3, 4 weeks out from now for the full hearing where all parties are involved. And so that ex parte hearing will consist of the petitioner and the magistrate, the judge, the commissioner, whoever it may be. And they will determine, based off the evidence you present, if they can grant a temporary ex parte order until both parties come back in the future for the full hearing where the defendant respondent could put on their evidence and case. So that's where my mind goes, only because, like I said, the original hearing referenced a prior petition that was dismissed. So I'm going to assume this was the commissioner who oversaw that and dismissed the original petition. So yes, he would have been familiar because he denied the original. Now, whether or not he told her what she needed to include, well, he wouldn't be allowed to do that because he's not allowed to give legal advice. But it seems like, yep, she originally came with claims that did not meet the burden. Right. Well, and it's res judicata too. That's what it's called. You're not allowed to relitigate the same claims twice. That's already been ruled upon. You mean if it's just online, Wolfie?
Still, and you have the right to still say, I don't believe that this is my child. And that's going to play out in the paternity case. So
It sure did.
I hope that answers your question, if not to your satisfaction.
Yeah, it would have to meet that specific statute for online.
I'm going to order that because this has been affirmed, that you please leave stuff. Oh, one other thing, I'm making a finding that these acts that I just found had occurred caused I believe that it caused the plaintiff to feel
Don't say threatened.
seriously alarmed, annoyed, humiliated, and mentally distressed. And
Okay.
So that's it made her feel that way as a subjective matter. And that it would have caused a reasonable person to feel the same way under the circumstances.
I don't know how long this order lasted.
I think I've completely given every reason that I can think of. And of course, anything else that's supported by the record is important. Now, please, everybody going forward, use your legal rights, use the legal pathways that are available to protect you. And I wish both of you the best. I appreciate your patience with me today. And so please leave separately so there are no hassles out in the parking lot. Okay? That's it. Where's what?
Your Honor, now that my legal services have come to an end in this particular matter, I'd like to make an oral motion to withdraw.
Yeah.
Thank you.
All right. So who's going to leave first? And does anybody want an escort to their vehicle? Each of you have more.
Okay, so yeah, it was already over.
I would just like to go first.
Sure. Is that okay? All right. Do either one of you want an escort to your vehicle? No? Okay. All right. Then you're good. All right. Good luck to both of you. I hope this eventually blows over for both of you. Good luck. Thank you. You're welcome.
Okay.
Yeah. I'll do that now. Yeah.
So
Laura, bring in the dismissal. I'll do it now before we sign off.
that's that.
Oh, you're good. Yeah.
Well, an appeal is based on an error. You know, when you appeal a decision, it's not because you don't agree with the decision. During an appeal, you don't get to bring in new evidence. You're not relitigating the case. You're not putting on another case. It has to be basically an error on the court's end of things. That, yes, you found out that the judge, there was ex parte communications that was not allowed. That can come up during an appeal. If the process, at some point during this process, this judge made an error and did not do something. But yes, okay, so that's a great point. And I'm going to have to look into that DMNMT. DMNMT. Is that a drug? It sounds like a drug. It sounds familiar to a drug. Not saying you're a drug. I'm just saying. I mean, who knows? You may be a drug. I don't know. But it sounds like something I've heard Joe Rogan say a bunch of times. I think that's just DMT, though. All right, sorry, my ADHD is getting sidebarred with you guys. But okay, if it was a 1-year protection order and that protection order has expired now and it's no longer active, I'm not sure what the protocol or process would consist of as far as clearing the record if it's not actively on the record. I'm not sure. I'm going to have to look into that a little more. Oh, I'm from Montana. Jeez, I'm tired. Montana. DMN Montana. Oh, okay, so not a drug. Not a drug. Montana. Yeah, to get it off his record, because you can't necessarily reverse it, it's already done. It's already expired. But as far as could you pull up and see that he's had a prior restraining order, you know? I don't know. I don't know. I'm going to have to look into that because I don't want to say the wrong answer when I'm not sure about it. But now the next live I want to go over the victims of Laura Owens website, and the same way we went through Michael's history, I want to go through Greg's history. But I also see that there are more calls to the Scottsdale Police Department, which I'm sure she's claiming he violated the protection order. So we're going to continue going down. Now I'm going to drop the link again to Schnitzel Ninja's channel. Has everything. Such a great channel. I use it every time I'm trying to show you guys something because they have so much on their channel. And then I'm going to drop the victim of Laura Owens website because it's fantabulous. And it has all the timeline in detail, but we're going to continue to go about that. So I will see you guys. I will be live again Thursday. I might be live tomorrow night on Patreon. I just don't want to say 100% yet because it depends on one thing, but I will be back live here on Thursday. So thank you all for hanging out. Thank you for doing a members only Tuesday with us. And I opened it up at the end. So thank you for anyone who may not be a member and joined us. We appreciate all of you guys. So I hope you guys have an amazing rest of your night, and I will see you all soon.